Give the public a minute to join the webinar. It sounds like we have a pretty good group. So let's just get started. Good morning, everyone. This is a beautiful morning. I'm sure everyone has read the court's order yesterday, and we'll probably discuss a few things later today. But without further ado, Devin, please take the honor and call roll for us, please.
Dr. Bolton,
LA office is still muted.
thank you.
Hey, go ahead.
Dr.
I
Cal.
just unmuted. Go ahead,
Dr.
Go ahead.
Dr. Bolton,
Yes.
Robert Brody, Dr. Cow,
Yes.
Alex Chan,
Yes.
Kareem Gangora, Larry Kaplan,
49, 22,
Paul Kramer,
here, exclamation.
Alex Lawrence,
Here.
Esther Lynn,
You can remember me in there.
Justice Macy Walla,
Here.
Okay.
And then
Bethany Peak,
here.
Ashley Silva Guzman, Judge Reyna,
Here.
Vince Reyes,
Here.
Alan Yokelson.
Here.
We have a quorum.
Okay.
Thank you, Devin. So as noted on the agenda for today's meeting, public comments during the meeting will be limited. Members of the public wishing to comment today were encouraged to submit their written comments prior to the meeting to ensure that the committee would have time to consider those comments. And the committee has received, and thank you. And we have read all the written comments. So again, we very much thank you for the public for that. And now, before we call members of the public in the order that they appear, I want to make sure we remind the public members that to facilitate hearing at least to facilitate this hearing and we hear as many members of the public as possible, I highly, highly encourage you not to repeat the points that were made by the previous speakers, and also to allow the CBE, the committee at the time, needed to deliberate on those important topics that we'll be addressing and discussing today. We will be limiting public comments to 3 minutes. And of course, depending on the number of individuals who want to speak, there's a possibility that we may limit that to 2 minutes, but we'll see. Now, for those of you who are participating today through Zoom, you should have a function for virtually raising your hand. It's a little hand icon, and you should see that at the very bottom of your screen. If you want to make public comments, please just click on that button, and Devin will make a note of that. And for those of you who are participating today by phone, you may also virtually raise your hand by pressing *9. Again, that's the star key and then the number 9. Devin will call members of the public in the order that they identify their raised hands, and she will enable the microphones of those speakers. Without further ado, are there any public members who would like to address the CBE today? Devin?
Yes, our first public comment will be from Benjamin.
Hello, I'd like to start with the order from the California Supreme Court yesterday.
Benjamin, it's a little hard to hear you.
Can you hear me now?
Much
We
better.
can.
Better, yes.
Okay. I would like to start with the order from the California Supreme Court yesterday on the portfolio bar exam. Like many of you, I was disappointed that it was not proceeding as is, but I do want to highlight that part of that was a reliance on the bar exam general bar exam criteria selected by the committee of bar examiners, which and what it as a statutory term, and part of that was noting that future advice about changes beyond what was made in that order to the bar exam would be handled by the Committee of Bar Examiners going forward now that the Blue Ribbon Commission's charter has ended. So I would encourage you to take those parts of the concerns that were solvable, which, given the situation with Oregon, that's quite a lot of them, and working forward on your work plan when you get to that agenda item today, in trying to solve some of the specifically the concerns about the supervisor disparity work products and those equity issues, and try and come up with a different proposal to be refiled in the court, so that there are alternative pathways to licensure being considered. The next point I wanted to address was that the time between this Sunday's deadline for the bar exam experiment and the time of that experiment already requires that the state bar effectively do the 2-week timeline I've been advocating for testing accommodation requests on the bar exam experiment. So that should be a good proof of concept for the feasibility of doing that timeline on the bar exam going forward. The third point that I wanted to make was that the standard conditions, specifically regarding testing accommodations and remote testing for the bar exam experiment, are not really clear at this point, which I think is going to prejudice some people in making this decision by Sunday. So there should be some additional information provided and maybe a little bit of an extension on that deadline. Thank you.
Thank you. Our next public comment will be from Amy.
Hi, how are you? I have public comment and I want to address the morality issue that you have on your agenda that I saw on the website. I have a lot of concerns about Heidi Soto and Kendrick Moxon and the attorneys that were representing the church, or I say the cult of Scientology yesterday. One attorney yesterday, which the people were attending the hearing, one of them had to go to the police because one of the attorneys shoved the Jane Doe in the elevator. That was absolutely unbelievable. How do you have people on the bar that do that, have that kind of behavior?
Amy, if I can stop you for a second. Devin, can you just stop the clock for a second?
Yes.
Before you go further, Amy, I would like to just remind everyone and also the public members that under the Bagley-Keene Open Meeting Act, public members or public comments must pertain to items that are on the agenda or be related to matters that are within the jurisdiction of this agency. And specifically, the committee exercises oversight on admissions matters, including the California bar exam, the first-year law students exam, more character applications, and law school regulation. The CBE does not have any authority over attorney discipline to the extent that's what you're alluding to. And there are no attorney discipline matters today on the agenda for today's meeting. So with that reminder, you may continue, but I just want to caution you that the subject matter for which you are providing your opinion may not be relevant for today's meeting.
I'm just doing that for public awareness that that's what's going on when you have when the attorneys are representing this church, or as I say cult. We also have to look at Heidi Soto and her behavior, her morality of not enforcing an RO because she's being influenced by a cult or a church that's in the town, that we have to also give some sort of in-services. I think you need to really address people in the state, specifically California, because you have the highest concentrations of Scientologists within your jurisdiction, and that they should be given a cult awareness course for education and given a course on safe pointing and fair gaming, and teaching them about how about lawfare and how this cult performs lawfare upon its public. And
thank you, Amy. I appreciate it.
Bye. Bye.
Thank you.
Our next public comment will be from Audit LA.
Yes, good morning. I'm here to talk about, you're talking about law schools, okay, and testing and training. And I just became a paralegal. I still have to do my certification. And do I feel prepared? Excuse me. No, I don't. And it's a bar certified course. And so I'm wondering if the lawyers that you're training, if they are prepared for certain things, like ethics. Okay, let's deal with ethics. And I too am here. I'm here to speak about Heidi Soto, Heidi Feldstein Soto as well, and her entire office. And I'm glad Ellie is here. And please do not interrupt me because this is relevant to law school training. Obviously, her people, herself and her people, her whole entire office are not well trained enough. Okay, because she is now the taxpayers now, because of that, have to pay for the her to get outside counsel to defend her office on compliance issues. So if there's compliance issues, they are either corrupt or they're untrained. And that is falls on you. Okay, their lack of training, right? And it's because you decide what gets trained. And so now as a taxpayer, I have to pay for this extra attorneys. I don't appreciate it. They are also not doing their job in the sense that I don't think they're trained. I was at a city hall meeting and the city council completely broke the Brown Act. I mean, to the point where I can turn it in, I think, for legal action and violated somebody's personal rights. The city, and that it was an attorney who said you are breaking the law, not the city attorney's attorney. It was a private citizen who did go through law training, maybe not in California, I don't know, and who said you are breaking the law. He was kicked out, okay, saying that, and his rights violated. And not one time did the city attorney who's representing the city council of LA step in and advise at all. And it was an absolute, it was a paralegal note, it was a Brown Act violation. So I am asking you guys, A, to put training extra for ethics, and B, Brown Act. These people need to know the Brown Act. And I even question you interfering with public comment. I understand if you're talking on agenda items, but you should not be interrupting with people's public comment. We have a right to speak. And with that, I will yield back the rest of my time. Thank you.
Thank you
Our
for your
next-
comments. Devin, before we go further, I want to make sure we remind the public that we do not regulate attorneys, and certainly it's not my intention to interfere, but to the extent any member is making irrelevant comments or discriminatory as well as harassing comments, it is my job as the chair to interfere to ensure that all proper rules are being complied with. So with that, Devin, please call the next member of the public.
Our next public comment will be from Bob Ferris.
Hello, good morning. Are you able to hear me well?
We
Yes,
can,
good
thank
morning.
you.
Thank you, appreciate it. So I am here actually to speak on the qualifications for the bar exam, particularly character and background. And I want to specifically ask if part of the requirements is to do a very heavy, thorough background check, as well as get legitimate testimony on a soon-to-be attorney's true character, because I don't believe it currently is. Because if it truly was the case, then why is it that on two separate occasions, City Attorney Heidi Soto, number one, let a man literally take his dick out in front of a fucking minor and take a shit in
Gentlemen,
public?
I'm going to stop you for a second. Devin, please stop the timer. I'm going to ask you to pause your comments for a second, Mr. Ferris. I want to make sure that I read the state bar's policy regarding discriminatory and harassment into the record. And I'm
This
going to
is
read the
not
policy.
harassment.
I think the language that you are reciting at this point is borderline discrimination harassment. And I want to make sure that we understand the policy. And so, Devin, if I may, the state bar maintains zero tolerance for unlawful harassment, discrimination, and retaliation. Employees must at all times treat all other employees, job applicants, and persons providing services to the state bar with respect and dignity and in accordance with this policy. Likewise, the State Bar will not tolerate harassment, discrimination, or retaliation against its employees, job applicants, or members of the public by any employees or by any person with whom the State Bar has a business, service, or professional relationship. Now, your comment, in my opinion, violate the State Bar's policy regarding discrimination and harassment and will not be condoned. The language you have used just now is not warranted, is unwelcome, and certainly not appropriate, and interferes with the ability of those present to listen and understand the issues at hand. And any State Bar employee who is offended or otherwise does not wish to remain present because of this language or due to the remarks is now excused from attendance during those remarks. With that, Devin, you may resume Mr. Ferris' time, and Mr. Ferris, you may continue your comments.
Hello, can you hear me?
Yes.
Oh, okay. Thank you. I just wanted to make sure. So another incident was when a known violator of a restraining order against a minor is intentionally being refused by the city attorney to be issued a warrant for their arrest, despite the judge actively testifying in court that this individual has repeatedly violated a restraining order, and yet law enforcement refuses to do anything about it, and specifically your own city attorney explicitly refuses to issue an arrest warrant. Now you tell me where in the entire process of somebody being allowed to sit on the bar exam went wrong for somebody to protect two separate child predators that are known Scientologists. That is not a coincidence. Two separate instances. And that's not even the worst of it. How is it then that two other people that are allowed to sit on the bar exam and then actually become judges who specifically issue bogus ROs, and the cases are beaten? Okay, you have Judge Rudolph A. Diaz, okay, and Stephen A. Marcus literally issuing bogus ROs as they are judges and were allowed to sit on your bar exam and harass protesters with lawfare. That is disgusting. They need to be disbarred, okay? And I know you guys have direct affiliations with the enforcement arm. So don't play like we're freaking children out here and as if one agency doesn't talk to the other. You need to permanently disbar these people for outright protecting child predators. And apparently it's fine if you're a Scientologist. That's the message you're sending. What you're sending to the public is that no child is safe so long as Scientology is out there, including your own children. Because what do you think Scientology does? Do you think they just stop at anybody's child? No, they're after everybody's children, including yours. Wake up and do your damn job. Hold these people accountable and permanently disbar them. Thank you.
Thank you, Devin. Before we go to the next speaker, I want to say the committee appreciate your participation, your perspective, Mr. Ferris. However, the issue you're addressing falls outside the jurisdiction of this committee, and with due respect, it doesn't relate to any item currently on the agenda. And for other public members who would like to speak today, I want to remind you that if you do not focus your comments on matters that are relevant to the work of this committee or the items before us today, this could potentially result in your public comment time being ended. With that, Devin, please call the next public member.
Our next public comment will be from Defender of Ants.
Can you hear me?
Yes.
We can.
All right. I want to talk about law school issues because you are the bar, and you're supposed to be holding it. You're supposed to be raising the bar. You're supposed to be holding lawyers to a higher accountability. With that, I want to give a shout out to Dorothy Gibbons for her successful win on Friday against the Church of Scientology. I want to give a shout out to Elizabeth Scully, Honorable Elizabeth Scully, the judge in that case, who ruled on Monday in my case that harassing words, I just heard the words harassing words. And luckily, in my case, the judge clearly said that telling people to fuck off or suck my cock is not harassing words. and that it's our constitutional right to free speech. And this is public comment. And I want to talk about what requirements you have in your law school of teaching. Do you teach your lawyers to make declarations that videos are true and correct copies, and that they're not allowed to turn up the speed and make it faster to appear like things happen faster? Is that how you teach your lawyers? Because that's what happened. That's what Kendrick Moxon did in the case on Friday. Honorable Elizabeth Scully ruled that Mr. Moxon was coaching witnesses on the stand in her order. Do you teach your bar certified lawyers to coach witnesses and tell them yes or no? Check out that order that happened on Friday. In my case on Monday, do you teach your lawyers to omit 40 seconds in a video after declaring that it's a true and correct copy? Is that the bar that you've set for your lawyers? Hopefully this is on topic. Hopefully my words don't harass you. We are the public. We are allowed to comment. You're not familiar with the harassment statutes in California, are you? Because nothing that Mr. Ferris said was harassing. Why don't you go after, you had the other lawyer yesterday, the Jane Doe, Chrissy Brixler, who's a victim of a serial rapist, Danny Masterson, be attacked by counsel. Robert Mangles attacked her. Robert Mangles is the counsel. Is that what you teach in your law, in your classes for certification?
Time has expired. Devin, would you please call the next public commenter? Thank you.
Our next public comment is from Mona.
Good morning. Can you hear me?
Yes.
We can.
Thank you. I'll be short this morning. Thank you for the opportunity to speak today. I'd like to discuss two items. One is continuing education credits that should include, multimedia areas of education for your attorneys on the bar. The second area is a closed item you have for the moral character standing incidents. There are two of your bar members. One, Kendrick Moxon. He is colluding and representing a cult that is in lawsuits for child trafficking and abuse. And two, Robert E. Mangle yesterday pushed an attendee of a court hearing in an elevator in an attempt to intimidate her. This is egregious behavior and certainly meets the requirement for your moral character standing incidents. Thank you, and I yield back my time.
Thank you. Devin, before we call the next member, I want to again reemphasize that the CPE exercises oversight on admissions matters, including the California bar exam, first-year law students exam, moral character applications, and law school regulation. We do not regulate attorneys. We do not regulate attorney disciplines. So with that, please call the next member.
Our next member of the public is Yvonne Best.
Hello, thank you for allowing me to speak today. The last item that you mentioned is about lawsuits, and I think that is very appropriate for the summation of what you are hearing today. Lawyers need to be prepared to deal with the legal issues surrounding high control groups such as Scientology, or the misfortunate cases of in history, Jim Jones and the all those people that wore Nike tennis shoes and purple suits. the legal system has a need for how to deal with these high control groups. And part of that is to take the internal documents and understand that they're using non-disclosure agreements, labor contracts of a billion years, and all sorts of trickery involved, so that when cases do get to court, the lawyers and the judges need to be fully aware of what mind warping concepts have been impacted on the plaintiffs and how they are being twisted in the courts of law. Forcing a person to into arbitration with the entity that has already abused them is like sending a burn victim into a burning fire. It is unconscionable that the system has no mechanism that is fully aware of the trickery that is involved in each of these kinds of groups. Now, as a lawyer, this would be a very lucrative client, because Scientologies and cults, the leaders of these organizations, bleed the money off of their victims, and it's sitting in a pile, and it's ripe for picking. Thank you.
Thank you. Who's next? Devin?
Mini Minion 7514.
Hi, can you hear me?
We can, thank you.
Thank you. Thank you for your time today. I would like to elaborate on my own personal experiences with the cult of Scientology. I grew up in Clearwater, Florida as a small child. My parents and my family was not, and we are never-ins. We were not involved in the Church of Scientology. But I was, and so were many other children in our neighborhood as they took over our complex. We were sexually abused, physically abused by the Church of Scientology as they trickled into our neighborhood. We were no longer allowed to play with certain children. We had to, basically, they threw us, families with children, to the streets because we were not a part of their organization. Okay? You just need to, people in this world, everyone needs to really step up for children's and children's rights. Children have rights today, more so than what we did when we were in the 80s, okay? I can accept what happened to me and the fact that it was brushed underneath a rug, but I cannot accept it any longer in society. People need to come forward. Whatever trail of whatever you need to do to get this going, ball on the roll, you need to do it. Step up, be the voice for these children who are suffering behind those walls, behind those damn doors. When I went back in 1996 to Clearwater, trust me, I did not have a friendly agenda on my mind. When I went back, as I remembered what I went through as a small child, having to see these dirty, disgusting, sleazy people's faces again, made it to the point where I damn near wanted to do something I would have regretted for the remainings of my life. Not only that, but I had to bear witness. I am a dead-ass witness to what those children went through as I was being brought into the Fort Harris Hotel because they wanted me, okay? Didn't realize who I was, and they cannot have me, okay? Having to see these children screaming, crying because they do not want to be locked into rooms with disgusting men and women who do not care, okay? Please, listen to what we're saying. Scientology is a cult. Please help these children. Thank you for your time.
Alex, I think you're muted.
Thank you, Devin. Before you call the next member, I just want to re-emphasize this committee exercises oversight on admissions matters, including the bar exam, moral character applications, and law regulation. The committee does not have authority over attorney discipline, and there are no attorney discipline matters today on the agenda for today's meeting. With that, Devin, please call the next member.
Our next public comment is from Taylor Israel.
Good morning. Can you hear me?
Yes, we can.
I have good news. I actually have thoughts on something that is on the agenda today. So given the Supreme Court's ruling yesterday on the decision of the Blue Ribbon Commission, there have been obviously a lot of questions and concerns in the community of legal educators who work with students and preparing them adequately for the bar exam. I know that it was mentioned that this would get discussed today, and item 4.1 and talking about the role of the committee of the bar examiners and the primary focus, there is a lot of concern around the edits made to recommendation 2 and the areas that are expected to be tested on the bar exam. And adding the 3 topics of employment law, family law, and estate planning, trust, and probate, given the CAPA report that the Blue Ribbon Commission was working off of, and highlighting how these were not necessary areas for minimally competent attorneys to be tested. And also the edits made to 0.1, where the language was changed from which would include federal law applicable throughout the United States, and that for certain subjects such as civil procedure and evidence, California law and rules may be applicable. With the change of taking out the designation for civil procedure and evidence there, it seems to imply that federal and common law would be required for every single topic, as well as California specific law, which would greatly expand the areas of testing on the bar exam. And that's in direct opposition to recommendation 4, which says that there needs to be a de-emphasization on memorization. And by expanding these areas that are required for testing, it is greatly concerning how this test is going to be developed and what it's going to look like, because it's going to increase the number of potentially required courses. It's going to increase what has to be taught in these required courses, and it will increase what students are and applicants are expected to know. It may also impact and bias out of state applicants, because will they have an opportunity to learn those California specific details? It's very different when it's only 2 topics compared to every single topic. So these are just concerns as you are discussing this that we would like to see highlighted in that discussion. Thank you.
Thank you, Ms. Isber.
We
Any
do not-
other public commenters, Devin?
We do not.
Thank you. To all the public commenters, your comments are well received, and we will now proceed to the remaining open session agenda items. Quoting the agenda, now we'll go into the chair's report. Is that correct, Audrey?
I'm nodding. Comment in the LA office. We have a public comment in the LA office.
Oh, thank you.
Thank you,
Please.
Dr. Cow.
It's more of a request. Can I save my public comment for after, for the end, for after the reports come in about the moral character?
No, the public commenters will have to make all the public comments within at this time. So if you have any comment that you would like to make, this is the appropriate time.
Nothing to say. Thank you.
Thank you. So now we'll go into agenda item 1.1, which is the chair's report. Well, again, good morning, everyone. It's a beautiful morning indeed, as I said earlier. But before we dive into 1.1, as we know, the court issued a non-banc order concerning the BRC's recommendations. And among other things, the court has added 3 new test topics to the bar exam and asked the state bar to explore whether unsuccessful applicants should be permitted to retake only the components that they failed without having to retake the entire exam. Now, the court also has placed an extra emphasis on the California bar exam strategies and stories program, which I intend to explore closely with this committee this year. But the most humbling opinion in the order is that the court expects that this committee will continue to serve as the court's steward and advisor to the bar exam. I, on behalf of this committee, want to take this opportunity to thank the court, the Supreme Court justices for the unwavering trust in the work that this committee does. And to Justice Mesiwala, Judge Reyna, Your Honor, Mr. Brody, Dr. Bolton, Dr. Cow, Mr. Kramer, Mr. Congora, Mr. Kaplan, Mr. Reyes, Mr. Lawrence, Ms. Lynn, and Ms. Siva Guzman, as well as Ms. Peak. The court's comment, it's really a testament to your dedication and how each of you has truly sacrificed so much to attend to the work of this committee. And it really should be so recognized so that the public is reminded that you put in that sweat, that blood, and those tears into various missions of this committee. And you do it all without any form of compensation. In my opinion, you only give, but you don't receive, and you still give no matter how much is asked of you from this committee. You could have spent your weekend on a nice golf course, on a sandy beach, or in a national park, but instead you spend it here with the rest of us. And so this is really inspiring. I just cannot ask for a better team than who we have today on our roster. So with that, if the any committee member would like to have a few words, you're welcome to do so before we dive into the agenda. Hearing none, there is one thing I would like to mention to all of you. Dr. Bolton's 92nd birthday is coming up. So I just want to take this opportunity to say happy birthday to Dr. Bolton. I feel like for the last 8 years, I keep on saying, happy birthday to Dr. Bolton, but he's still here. So thank you. Dr. Bolton, anything you would like to say? If I were there, I would buy you a birthday cake. But, this is, I yield the floor to you.
Just glad to be here. Thank you. It's a privilege. And a learning experience.
Well, hopefully at the next in-person meeting, we'll be able to celebrate your birthday in grand style. But thank you for being here today. Let's talk about the next agenda item, which is 1.2, and this is the Committee of Bar Examiners work plan. I'm going to hand it off to Tara to help us go over her part of the plan. And then we'll also talk about the planning meeting in December as a way to help us design the new work plan for the CBE for this upcoming year. So Tara, can you take the floor?
Thank you. And I believe Devin's going to share it. And I think this time, rather than jumping around to our different areas, we're going to just scroll down the document. So Devin, if you can move down to the moral character section, please.
Sure. 1 second. Let me
No problem.
share the document rather than my screen. Okay.
So just brief update on the moral character section is that we just have our presentation regarding rehabilitation by David Lane today in open session. And if you keep scrolling, let's see, Amy or Cody, did you want to say anything about the Access Lux grant?
No, there are no changes to that section.
Okay, so you can keep going, Devin.
Oh. So go ahead.
You can keep scrolling, Devin, sorry.
Can we stop here for 1 second? So here is a call out for the examination, something that was modified since our last meeting. So the standard setting study to determine whether the passing score for first year law students should be raised or lowered, that was completed in August when the committee approved the minimum score to pass a first year law student exam when we shifted to an all multiple choice exam. So I want to highlight that. And I also want to call the last item on this grid here. This will reflect differently for our next meeting. As you can see here, the court now has made a recommendation in regards to the BRC recommendations that it received. And so this will change as a priority for our next meeting. As Alex mentioned, when we discuss our priorities at our next meeting or planning meeting, we could talk about this as well as the next item that's on this grid. If you go down one more, and that is related to the portfolio bar exam. So we will talk about the priorities. These will be part of that discussion at our December meeting.
So is it fair to say today we're just kind of energizing our thinking caps and we shouldn't pick over the details until we come back in December?
Correct. So right now we're highlighting the modifications from the last time we discussed a work plan to this time, but in December we'll have more time to dig into the details. All right, and here we have one more. So we are going to have a presentation today on the basics of performance test development. Sorry, I believe that's the next screen. There we are. So that's happening today, the first item on that grid. One more change here. So an update is that we have completed both Supreme Court reports that are due during this CBE calendar year. In August, we submitted the February 2024 California Bar Exam Supreme Court report. Okay, so I want to pause here again. So as you can see here, there is a review and revisions of the admissions rules relevant to exam administration. So these are Chapter 6 rules. I'm not sure if you recall, but a draft was approved by the committee in late 2023. And we're bringing this back to the committee to review once more with a new lens, given that there are potential changes forthcoming related to the bar exam administration. So with the potential of a hybrid exam, that is a remote exam and now an in-person exam with vendor contracted test sites, staff recommend that the CBE revisit exam security policies with these changes in mind. So we'll be working with, we're going to identify volunteers from the exam subcommittee to work with the staff to develop a proposal that we hope to bring back at the December 2024 meeting. So that's what's coming up with the Chapter 6 rules.
And then just briefly mention here, we've just revised some of the rules dates. As you can see, we're continuing to bring them forward. We're just trying to spread out the timing of them. So we'll continue to talk about this at the December meeting, but you can keep going, Devin. Thank you.
Okay, Devin, maybe we can touch on this first item, but also in just a moment, scroll down to the second item because I think they're tied. But when it comes to the work plan item to pursue mandatory accreditation and or initiatives to improve outcomes for unaccredited law schools, this has been an ongoing process. We've sort of split this item into two with the mandatory accreditation discussion requiring further discussion. But the second piece, the initiatives to improve outcomes for unaccredited law schools have been brought to the committee and they've been a part of the second item. If we could scroll down, Devin, they've been part of the proposals brought forward as part of the second item, which is reviewing the unaccredited law school rules. We have this listed as ongoing, and our goal remains to bring something actionable to the committee in December, but I want to take this opportunity to provide a quick update. In August, we brought to the committee a first draft at a review and proposed revisions to the unaccredited law school rules. We don't have a second draft today, but we have, since that August meeting, solicited feedback from law school deans. We have met with liaisons from the Council on Access and Fairness. And just this week, we brought that initial draft of rules to the Committee of State Bar Accredited and Registered Schools, CS BARs, for their input. And that discussion was very robust. In fact, it warranted the scheduling of an unexpected second meeting to make sure that all of the members of CS BARs had an opportunity to share their input. So I want to note that the feedback process from our stakeholders is ongoing, really in full swing at this point. and we're gathering a lot of great input from the law schools themselves. And then if we could keep, working our way down. The last item on the screen here, exploring requirements for California accredited law schools to require courses regarding the competent use of generative AI and regulations or rules related to the bar exam in generative AI. We have a discussion on today's agenda to kick off an initial exploration of these topics. So we'll get into that more today. We hope that today's feedback will provide staff with some considerations and input to take back and inform action in December of 2024. But that is something that I think we'll dive into later today. I think that's it as far as updates on my end. Thank you so much.
Thank you, Cody. Audrey, to the extent the committee wants to add items to the work plan, is this a good time to talk about those items, or should we wait until later in the day to go through those items?
I mean, since December is the planning meeting, it might be better. I like, what Paul was saying in terms of everyone's marinating on the order from yesterday, and then coming back with our agendized planning with what we want, kind of the roadmap for the rest of the CBE year to be. We can look at what items, maybe didn't get addressed from last year's work plan, but then really plan for a lot of very beefy policy exam related work. So, but
that makes sense. So I guess all the members will have to come prepared in terms of any items you would like to the work plan. I personally have two things I would like to add to the work plan, but I can wait and defer until the December meeting to do that. But because I know some of us may be, away for family obligations due to the holidays, to the extent anyone has anything that they would like to add to the work plan, but they were not able to attend the meeting, by all means, shoot me an email or Audrey, and we'll add those items to the work plan. Okay, anything else for agenda 2.1? Oh, excuse me, 1.1 or 1.2 in this instance. If not, let's go to item 2.2, which is the approval of our August 16, 2024 open session minutes. First, to the committee, any questions or comments?
I'll make a motion to approve. This is Kareem.
I have two suggested corrections. One is on the first page, renumber 5.1 and 5.2 is 1.1 and 1.2. I think there was just a typo there. And then on item 4.1, which was the first year exam, I believe, it says resolve further that the committee will revisit the success or the outcome of this motion within the next 4 years by 2028. I would like to add a more specific reminder because I know we spoke to it at that meeting. And so after the words outcome of this motion, I would like to add including the predictive value of the exam regarding future licensure. And remember, one of our goals with the first year exam is to let people know if they're on, if they're likely to be able to become licensed or not, and with the idea that maybe they will consider whether they should continue on the path if it is very unlikely that they will be successful. So I just propose those revisions.
Paul, just to be clear, are you suggesting that we change the language of the motion that the committee adopted, because we'd have to have a new motion to change what was adopted by the committee?
Okay, well, I didn't look up the tape to see. All right, I'll withdraw that. I just, this is going to be the only thing people are going to be looking at 4 years from now when we've all turned over, and I just hope we remember. But that's really that's the main question we want to answer, I think. So just do the renumbering.
Thanks, Paul. Yeah, the numbering sounds feasible to me.
This is
Any
Jessica
other
Cibola. With that one amendment, I would second the motion.
Great. We have Mr. Gongora calling for the motion, and we have Justice Misiwala seconding the motion. Any discussion or debate? Hearing none. Devin, please call roll.
Dr. Bolton,
Yes.
Robert Brody,
Yes.
Dr. Cow,
Yes.
Kareem Gongora,
Yes.
Larry Kaplan,
Yes.
Paul Kramer,
Yes.
Alex Lawrence,
Yes.
Esther Lynn,
Yes.
Justice Misiwala,
Yes.
Bethany Peak,
I think she said yes. I just muted.
thank
Oh,
you.
yeah.
Ashley Silva Guzman, Judge Reyna,
Yes.
Vince Reyes,
Abstain.
Alan Yokelson,
Yes.
Alex Chan,
Yes.
with 13 yeses and 0 nos, the motion passes.
Thank you. Now, in addition to the approval of our August 16 minutes, we also have our September 30th open session minutes for the meeting that we had last week. So I'm going to open up the floor to see if there are any questions or comments for item 2.2.
I'll move approval with the correction that 4.1 should be numbered 1.1.
Thank you, Mr. Kramer.
I'll second the motion. This is Vince.
Thank you, Mr. Reyes. Any further discussion? Hearing none. Devin, please call roll.
Dr. Bolton,
Yes.
Robert Brody,
Yes.
Dr. Cow,
Abstain.
Kareem Gongora, Larry Kaplan,
Yes.
Paul Kramer,
Yes.
Alex Lawrence,
Yes.
Esther Lynn,
Yes.
Justice Misiwala,
Yes.
Bethany Peak,
Yes.
Ashley Silva Guzman, Judge Reyna,
Abstain.
Vince Reyes,
Yes.
Alan Yokelson,
Yes.
Alex Chan,
Yes.
with 11 yeses and 0 nos, the motion passes.
Thank you, Devin. On to agenda item 3, consent agenda, and item 3.1, which is the report of administrative updates regarding law schools. I understand Ms. Leonard will be reporting. So Ms. Leonard, the floor is yours.
Yes, if there are no questions, the report details an update as to a new dean provided on a scheduled basis from UC Davis. The prior dean announced his planned retirement after a long period of service last summer. If there are no questions, I would entertain the motion.
Thank you, Ms. Leonard. Item 3.2.
Oh, I'm sorry. I thought we would. Not a
Yeah, I
motion
think what
for
we
the-
do is we typically do is we just go through all the items under the consent agenda, and then we'll
Oh,
go
sorry,
everything at
sorry.
once. No, you're
Sorry.
good.
I saw UC Davis and
You got a little
thought-
excited.
I thought of us.
I don't blame you. All right. Item 3.2, we have a technical report on the June 2024 first year law students examination with Mr. Gallang. All yours, and Adrian.
Thank you, Chair. So for this item, we do have the technical report for the June 2024 administration of the first year law students exam that was provided to us by ACS Ventures. Notable items in the report. So this is the first year exam where we no longer tested essays. So this was an all multiple choice question exam. So within the report, it details the scoring process as well as the how applicants will be able to calculate their total scaled score. And then another thing that I did want to note, just within attachment B on the general statistics, the overall pass rate for the exam was 32.5, which was a pretty big increase from recent June administrations. And then does anyone have any questions on any item or attachment?
Any questions from any member of the committee? If none, now.
Alex?
Mr. Brody, yes. Yes, Alan.
Oh, Adrian, can you give us an idea of how much an increase this is? Maybe just give us a couple of the past results.
Yeah. I'm glad I pulled that up. I kind of anticipated that. So in June of 2023, the overall pass rate was 13.7. June of 2022 was 19.6. June of 2021 was 20.7. June of 2020 was 22.5. So I think from 2020 to 2023 it was trending down, but now we had this big uptick.
And it was what again this year?
Eliminated, yes, it's
32%. Yeah.
Thank you.
Of course.
I guess the only difference between this exam versus the one last year was the fact that we eliminated the essays.
Correct.
I mean, the pool obviously is different every time too, but.
Well, and you changed the minimum pass score as well.
Right, that's what, yeah.
Mhm.
Okay. Okay, well, the consent calendar is voted on and typically approved as an omnibus item. And so, Mr. Brody, you can now make your motion.
To approve the consent calendar.
Correct.
Second. This is Alan, I'll second.
Thank you, Mr. Yokelson. Any discussion? None? Devin, please take the roll.
Dr. Bolton,
Yes.
Robert Brody,
Yes.
Dr. Cow,
Yes.
Kareem Gangora,
Yes.
Larry Kaplan,
Yes.
Paul Kramer,
Yes.
Alex Lawrence,
Yes.
Esther Lynn,
Yes.
Justice Misiwala,
Yes.
Bethany Peak,
Yes.
Ashley Silva Guzman, Judge Reyna,
Yes.
Vince Reyes,
Yes.
Alan Yokelson,
Yes.
Alex Chan.
Yes.
With 14 yeses and 0 nos, the motion passes.
Thank you, Devin. On to agenda item number 3, which is, agenda item number 4, which is the business matters. 4.1 is discussion on California Rules of Court, Rule 9.6, and the Committee of Bar Examiners' roles and responsibilities. Audrey, I believe you have a report, so please take it away.
Thank you. So the second part of that item title first, talking about CBE roles and responsibilities. This is actually the first official meeting of the CBE year. We don't have any new members currently. So everyone here has been through orientation and through at least a year of service. So knowing already what the roles and responsibilities are, to that item, I attached legal authority, the Business and Professions Code, Rule of Court, and then, of course, the admissions rules. Also talking in that item about CBE's interplay with the Board of Trustees and the Supreme Court. But I'm going to share my screen now and talk a little bit more about Rule of Court 9.6. Okay, so actually Ashley is not able to make the meeting today, but she asked an important question at the September 30th special meeting right toward the end, which is why I wanted to agendize a conversation today. And her question was, how did we get here? How did we get here? Meaning having to call a special meeting and go through those approvals once we had that petition on bar exam changes denied by the court. So I wanted to kind of narrow into this kind of question about why we did that session and how we got there. So Rule of Court 9.6 actually has a couple more parts to it, but this is the most relevant. Although when Amy was going through the work plan, she talked about those reports that we submit after every bar exam. The committee reviews them and then we submit them to the Supreme Court. That's actually in Rule of 9.6 as well. But the relevant part I've highlighted here about the Committee of Bar Examiners pursuant to the authority delegated to it by the Board of Trustees, again, this interplay between these three bodies, is responsible for determining the bar examination's format, scope, topics, content, questions, and grading process, subject to review and approval by the Supreme Court. So I added those bolded words, but I think they're important, again, for the focus of this conversation. So in terms of how we got here and from like a helicopter view of like decision making from June of last year through that last meeting we just had, just wanted to highlight a few things kind of from the perspective of public meetings and decision points and how we got here. So we had CBE liaisons working with staff on the finances. And back in June of 2023, there was a motion the CBE had about cost savings to reduce the number of exam sites and have 1 day of remote testing. So we were talking about remote testing as a modality through 2023, but in terms of testing the California materials, the written materials remotely, because we were still beholden to the multi-state day being in person because of the restrictions of the NCBE. So that was a conversation and a recommendation back in June of 23. August, there was a board meeting, and then that recommendation was actually just to reduce the number of test sites to try to reduce costs. So nothing about remote testing. And then in November of 2023, we had a public forum about remote exam delivery and getting ideas from members of the public of how we can securely deliver the exam remotely for applicants with testing accommodations. And members of the CBE were at that forum as well. January of 24, so moving into this year, the Board of Trustees approved administering the July 24 exam at a reduced number of test sites, but further wanting exploration of remote testing. March, we had a CBE meeting talking about contracting with the new vendor to develop those multiple choice questions, talking about how that would allow remote testing, and then focusing, of course, on this projected insolvency from our finance unit here, talking about the admissions fund becoming insolvent by 26. So that was a discussion only meeting. In April 16th, right before another CBE meeting, we had a large public forum talking about changing question vendor and talking about remote delivery, having a lot of back and forth with the public there, and CBE members were at that forum. Then we had a CBE meeting April 19th, and then the recommendation was to contract with a new vendor for developing bar exam questions. The item itself talking again about remote testing to allow the ability to test remotely, but the recommendation was about a new vendor for multiple choice questions. July, Board of Trustees, and interveningly, you'll remember between April and July, we actually had to pull an item off from the board meeting, but that item was back on in July, authorizing entering into a contract with Kaplan for developing those exam questions. That contract was signed on August 9th. We submitted a petition to make the bar exam changes on September 9th, and that petition was denied without prejudice by the court on September 18th. September 19th, there was a board meeting approving to move forward with a contract with Measure Learning for remote and in-person test administration. And then you will remember, because it was very recently, we had that special meeting doing explicit approvals about Kaplan drafting those multiple choice questions, Measure Learning as exam delivery vendor, and then the modality of remote and in-person using vendor run test centers. So that's just a recap, but kind of how we got here from the actual meeting roadmap. But this was the explicit language. The denial was very brief. But saying it was denied without prejudice to a future petition, and we did file on October 4th, seeking modifications that have been considered and approved by the Committee of Bar Examiners, and then referencing that exact rule of court 9.6. So from this, we infer that the court is seeking clear approval processes for significant changes in exam delivery and administration. So, and that is why we had that September 30th meeting, making sure that we got those explicit approvals from the committee for those significant changes in the bar exam. So in the item that I wrote, talking about the CBE role, policy oversight being a really key role of the Committee of Bar Examiners, today, one of the discussion items about generative AI, like that is something really robust and policy driven that we'll need the committee to weigh in on. It actually was mentioned in the order from the court yesterday as well. CBE is also an appeals body from like moral character determinations, testing accommodation petitions, exam rule violations, eligibility, law school regulation, the first year law students exam, and of course the bar exam. And Alex already alluded to this, but I thought it was worth calling out in yesterday's order. It explicitly ended with this sentence about the court's expectation that the Committee of Bar Examiners will continue to serve as the court's steward and advisor as changes are implemented to the general bar exam. So I think that's pretty clear, and we have a lot of work to do. So thinking again for December planning meeting, getting a lot of ideas in mind for that meeting, beginning to map out the court's order, and then thinking about those specific things I started off with, which is format, scope, content, questions, grading. Those are all very explicit. And I think we have a much better idea now, the staff and the Committee of Bar Examiners, about what we need to do from that Rule of Court 9.6 and from yesterday's order, because obviously all those major changes to the exam and creating our own California bar exam is right in the wheelhouse of the Committee of Bar Examiners. So a very exciting time, but that was my brief kind of dive into the how did we get here. I don't know if anyone has any questions.
I'll just point out that the court's statement used the word continue, that the CBE continue to be involved in these processes, but my interpretation is that they want us to be more involved than we recently have been. Because to continue the status quo would be to continue something where we are not asked to approve things, but told what's going on as a courtesy by way of a report. And I think the court wants that that relationship to be upgraded to one more of equals and partners with staff, as opposed to bystanders.
Maybe it's continue as of September 30th and now moving forward with all the future planning we need to do for the bar exam.
Okay, well, in that sense, yes, there's the recent change, so continue the recent change, and that is consistent with my interpretation as well. But it's, you know, it's hardly a trend. One event does not make a trend, so we need to keep it up.
I just want to respond to that a little bit. I would say I think Audrey's timeline shows that we really were doing our best to keep the committee involved in all of these kinds of discussions dating back to June 2023. With respect, I just want to respond as far as staff goes, that if you look at the specific provisions of 9.6 that she put up, from our standpoint, we thought we didn't see anything that specifically needed to be done with respect to the February bar exam that we're proposing now that fell specifically within those 9.6 guidelines, because we weren't exactly changing the exam. We were changing the modality of the exam. And we kept we had the liaisons, and we had you vote to recommend it. But from our standpoint, we didn't interpret that provision of 9.6 to expressly require the approvals. So for what it's worth, we did what we could to keep the committee involved, but we didn't tee up those specific resolutions based on our interpretation 9.6. Now we see that the court, ruled differently. And so that's why we presented all of those going forward, on September 30th. And I agree with you, but I just wanted to let you know, I do believe that we've made a real concerted effort to keep the committee, in the loop and advising us as we go, as far as all of these changes.
You certainly have told us about the decisions that staff has made, one might say on our behalf, and that's a little different than us being presented with the decisions. And it's a much longer trend than when your timeline started. I think we're talking about this today because Ashley Silva Guzman asked at our September 30th meeting, how did we get here? And my interpretation of her question was much broader than just, you know, the statutory and rule provisions that define the scope of our authority and obligations. We were put in a position that we really had no other option than to approve what's proposed for February, because the deficits, the budgetary shortfalls have been going on for so long that we were painted into a corner. We really couldn't consider a more measured and careful, slower rollout of the new questions that would allow us to calibrate them against the MCBE questions and address concerns that I, for one, had about whether we were rescoring the test or effectively changing the cut score. So, and I've been agitating, as many of you remember, for years now that, we receive more information about the budget, so we can spot trends that might put us in the very place we found ourselves, and perhaps avoid them. I am glad to see that the court has, I agree with Alex in his opening comments. It is heartwarming to see that the court has expressly dealt us in again. And I look forward to working with staff to improve the bar exam and get the budget back in balance.
Thanks, Mr. Kramer. Anyone else? I just want to say very quickly that I also have a fluid communication channel with the board, and it's certainly I talk to Audrey on a weekly basis and Bridget's, and so I'm sure for future references, I'm sure we'll all work together for the benefit of this committee, and we'll make sure that if there's anything that needs the committee's review and recommendation, that those items will be coming to us first. Again, I think it is part of also my job as a chair to make sure that this happens, and it is obviously my endeavor to do that. But thank you also for the staff for keeping us in the loop. I'm glad you guys came to us and we were able to ratify the issue. Again, we are all working for the benefit of the state bar, and I'm glad we were able to collaborate and succeed in that way last week. Okay. Anything else? If not, we'll move on to the next agenda item, which is 4.2. It is the update on 2025 bar exam planning and action on remote administration of bar examinations for examinees electing to test out of state. And I believe we have a report from Audrey, Cody, and Amy.
Yes, me again. So we're gonna do the item. This is kind of twofold. We're gonna update you on some what's been happening. I guess not too long now since our last meeting, and then we left a decision on the table that we need to get back to today about test takers who are out of state. So okay. So we talked about this many times over this year about content validation, how it works, what we're doing with the questions. We've had batches of questions, the drafted questions from Kaplan, and then we get the psychometrician and a panel together to review, and then they go back to get edited. And the panels are looking for minimum competence to make sure the questions are free from bias, they're legally sound, etc. So we have all these meetings planned. They're usually full weekends in person because they're, of exam security. So if any of the volunteers are watching the meeting, thank you so much, because it's a volunteer effort to get these questions validated. And it's quite a big lift, and everyone's been really terrific. So we have panels going pretty much every 3 weeks until the end of the year. And then we will continue to get drafted questions and continue this process. But this is just about the February questions. Next slide. We also have been preparing the faculty guide and student guide. We're trying to get those out this month. We have the drafts from Kaplan, but we're going through that same process to review and make sure that we also have it formatted in the way that we want to hand out to the faculty and the staff to use. So our expectation is to be able to publish and release those by the end of this month. And I think Amy has the next update.
Great. This is an update on the contracting for the February 2025 exam. So we're currently working with the exam administration vendor and our general counsel to finalize the agreement in preparation for that exam. And to date, parties have agreed to high-level terms. And some of the items that are being addressed in this contract include customer service, which includes things like the tech support availability, exam delivery, and security protocols for both the in-person and remote exam. And so we'll work with our committee volunteers to review some of this material and provide feedback. All right, so next I'll talk about the experiment. So I want to remind the committee of the goals of this experiment, and they are to field test 49 new multiple choice questions and to operationally test the measured learning platform. So on November 8th and 9th, we plan to administer the exam using remote live proctors and with applicants testing in person at measured learning test centers. All will be on the measured learning platform. Staff worked with the vendor to secure an additional test date on that Saturday in response to concerns raised by law schools and law school deans about the MPRE testing dates and work and school schedules. We're very happy with that outcome. We've received about 4,400 applications, a little over 4,400 applications to date. On October 2nd, we held a Q&A session with law school administrators and applicants. And as a result, we updated our bar exam webpage that's dedicated to the bar exam experiment, our FAQs. And again, this is in response to the questions and feedback that we received. And we are very excited about this unique opportunity that's coming up.
Amy?
Right, yes.
Oh, Amy, hi, it's Robbie. Can I just jump in real quick?
Sure.
Have we selected, or has Measure Learning selected the test centers where the experiment is going to take place?
The experiments are going to take when somebody elects to take the exam in person, the experiment exam, they select the place that the applicant selects it. So it's from the directory of test sites that are available or provided by Measured Learning. It's a applicant that elects where they'd like to go.
And is that something that we can see, that the test center selections? I would like to see what is being offered to the applicants.
Okay, we can send a list, but it's on their website. But we can send that.
So I mean, I would imagine the list is very long because they subcontract with tons of places. So will we know who's testing where? I asked that because I'd like to attend, just like I attend bar exams, to be the eyes and ears of the state bar and the court to see. It's an experiment for us as well, to see what's being offered and what's being provided, because no bar staff will be there, I think.
I appreciate.
You know what I mean, Amy? I mean,
it's what we've done in the past where we've allowed the CBE to come and observe the test administration. I think we'll talk to the vendor about that possibility, and I could follow up with you. And maybe anybody else who's interested, let me know, and I'll research this and let you know, because we won't have a meeting between now and when that experiment happens. So I'll keep everybody updated via email if you just let me know who's interested.
And I would like to thank Robbie for volunteering to be our liaison working with this. So that's another great idea, Robbie.
Thanks, guys. Yeah, please keep. I am on that subcommittee, but I would like to see myself either day or both days. I'm not exactly sure. I guess, do we know yet who has asked to take that exam in person?
We do know who's asked. What we haven't done is send the assignments. That is, the application closes on October 13th at midnight. And on the 14th or on the 15th, we'll be looking at who is selected to make sure everybody's met the eligibility criteria to be in the experiment. And then we'll send out invitations. When those invitations go out, applicants are required to schedule their examinations. And so that's when we'll know. So we really won't have a final list until probably the end of the month. So by the end of the month, we'll know who's taking it in person, who's taking it remotely, and specifically what you're interested in is where they're taking it as well.
Amy, is there a set number in terms of applicants that we're selecting, or are we admitting, provided that all the conditions are met, are we selecting all the applicants?
We have 4,300 spots available.
We
And
have
like I
more
mentioned-
than that now because of Saturday. So we're really trying,
Right.
we added way more seats. So we're really trying not to limit. The only limit is some of the in-person testing sites because they didn't expect us to open up Saturday. So, but based on the percentage of folks who are requesting, we're hoping to meet a lot of those preferences.
And remind me, have we set the dates yet for the experiment?
Yes, November 8th and 9th.
Thank you. Yep.
And hey, this is Robbie. Amy, I'm sorry, just I know this experiment is coming up, but I know we have an amazing procedure when we give the exam in person. If there's a complaint, it's too hot, it's too cold, I need this, I need that, my computer. How is that going to work with this vendor at the in-person sites? Have we, I have a lot of confidence with Measure Learning in their remote administration because I've read lots of reports on how well they do that. I am a little bit more concerned about their administration in person because they don't actually do it. It's their vendor, third-party vendors that does it with, I suppose, training from them. And I'm not sure if there's going to be, I guess the input we provide is to Measure Learning, and then they provide that to their vendor designees. But do we know what's the procedure in place if there's a complaint or a concern from an applicant? My test is missing a page. How is that all going to play out? And I don't want to put you on the spot if you don't quite know yet.
No, we do. We've conveyed our standards and our rules and procedures, our policies to with Measured Learning. We've had multiple meetings and are still finalizing the process. So for example, things that we do at an exam, such as like incidents that come up, whether it's a security incident or something that you described, like a missing page in a document, or somebody got the wrong exam material, whatever the case might be, they'll be handling it like we do at our test sites. You prepare an incident report, and then we investigate that matter, but address the applicant on the spot. So our materials are, they have our materials, they have our guidelines, and also the other standards, things like you mentioned related to the temperature, what allowable items, prohibited items, all of that has been discussed and is being negotiated with Measured Learning. So for the applicant, it'll feel like the bar exam or the first year law student exam, except that you are not going to one of our sites. It's at one of these Prometric test centers. So our standard, Measured Learning, sorry, I forgot what I said. So our standards have been conveyed to this vendor.
So, I have not seen this part of their website. I would imagine they have quite a lot of potential test centers. I would propose or prefer that we limit the choices geographically to, maybe just one per area. I don't know how they're doing it, but, one in San Diego and one in Orange County and one in LA and one in the Bay Area. I don't want to spread our applicants and our resources around too far.
Well, the point of one of the goals of this experiment is to test the platform, to test the questions, and also to make this convenient for our applicants, like so that we'll get to learn more about a variety of test centers, not just by selecting or limiting the number of test centers that people visit. Also, we're hoping that applicants or those that are study participants that are selected select something that's close to them. I think making applicants travel far, this is a 2-hour session, so we really want to make it convenient for the study participants. And I think that's a big consideration in terms of allowing them to select something close to them rather than limiting that option for them.
But Amy, I feel like the bar is making it convenient for applicants by permitting them to take it from their home. That's the convenient part. I think that doing it any other way, which is so much more costly for us, is an accommodation that is I want to balance the needs of the bar to effectively administer the exam with the needs of the applicants. I mean, I think our discussions for the past year is almost everybody wants to take the bar at their own location where they have access to this and that, and we're doing it. So I think that those that want to take it in person, I'm not sure if we need to have 100 sites to be close to every single person. I don't have a problem with limiting that so that we're limiting our resources and the number of different people that give instructions to applicants. I think you minimize the chance for error when you limit the number of places that things are going to be administered. I mean, that's just seems like a more efficient way to do it.
Well, you're right, Robbie, that most people are want to take it remotely. Our numbers are panning out that way. We have I think maybe like 14% of the people want to take this exam at an in-person test site. And I think what factors into that decision is also whether they have the testing space at home or adequate testing space. Maybe they're nervous about the laptop compatibility issue. So, that's why this is being offered. But you're right that the majority of folks want to take this remotely. We'd have to go back and talk to the vendor if we want to limit this. That's not what we've negotiated, because again, we wanted to make it convenient for applicants, and we also wanted to test as many sites as possible and gather feedback. There is a survey component at the end of the experience after they finish the multiple choice questions to inquire about that, about the quality of the platform itself, about the site, and so. I could take
well,
this.
then I mean, this is the purpose of talking about it at the meeting, I suppose. My recommendation, Audrey and Amy, would be that as part of this experiment, that we have a state bar staff member who is so familiar. Becky's staff. She's right there, so she's probably, giving me the evil eye, that a staff member of the bar visit every site where someone is taking the exam in person. We know how to do it. We have 50 years of experience in administering the exam, and I go every time, and I'm always very quick to point out how careful we are with our applicants and making sure that they have a safe and effective environment. I think for this test, I would ask that the people that do it anyway, the people that administer the exam for the state bar, that everyone be asked, depending on how many sites there are, to personally get a hands and eyes on view of it. I think that should be part of the experiment. Let's see, are they doing it like we do? Because boy, if they're not, then maybe, Becky will want to have a person at the February exam sites to do the administration, and then we'll get a credit from Measure Learning because we won't use their staff. We'll use our own. I'm praying that we have 95% of our applicants who want to use their own site, because that's what I hear that people prefer. But for this experiment, if you can do it, if there's staffing, I mean, everybody from, Donna on down, we've all done it before, and I'll go to a site every day, and Alex Chan apparently is flying in just to do the same. So
I'm actually going to suggest that I'm going to be there on the 8th and the 9th.
Oh, well, and part of the whole their conversation also is a little later with the resolution in terms of where there might be if someone is testing outside of California. So just keep that in mind. And the staff has made site visits, but I think it's a good idea to do more of the site visits. Again, since the application hasn't closed, we haven't looked to see where the people who preference in person are. I think that it's a little premature to say where test centers are going to be because we don't really know where the test takers are yet. So, if no one in that preference pool wants to take the test in Sacramento, we don't need to tell Measure to have a site there, right? So we need to look at the actual, once the application closes, to see what the pool is, where they are, and then where those test centers are. But I think once we kind of narrow that down, the staff team and Robbie, you as the liaison or whoever else wants to can look at where the applicants will be testing and see if you want to do a pop-in. I think that makes sense.
Well,
I see that Judge Reyna's hand is raised.
Yeah, I just had a general question. I wasn't able to make the September 30. I watched some of it, but so these test centers, when we have the experiment and going forward, is it just folks that are taking the bar exam, or because I know in some test centers you could take other tests, and I just that's unclear to me, and I don't know if I read that anywhere.
So it'll depend, but it's possible because they have a lot of different clients that's what they do, administer exams. So it's possible that we will have a whole center that will just be our test takers because of our volume, and they call those like a pop-up center. So that would just be our test takers, or it could be one of our test takers who preferences remote, especially if we are talking about out of state, out of California. They might be there with someone who's taking an FAA exam or something, but the proctoring situation is consistent for all the test takers.
Can I offer a link to Robbie?
Sorry, let me just finish. I just wanted to, so I just was wondering the feasibility then of watching, if that, well, let me back up. Is the November 8th and November 9th experiment, is that just going to be exclusively in-person state bar, or no? Because I imagine, I mean, going to one of Robbie's questions, I imagine the purpose of it is, people maybe don't have a stable internet connection, or they want to go somewhere separate to take their test rather than in their home. And so that's why they might choose in person. And with all these test centers, they can go to the one down the street versus one across town. And that's the purpose of it, it would seem. But I just wanted to be clear then that that it might be, they're taking it with non-bar exam testers.
Just like the MPRE is at Pearson View Centers, and they're taking the MPRE next to someone who's taking a different test. It would be like that. So the 49 questions that are tested on the 8th and 9th, that's probably about 90 minutes of multiple choice questions, and they can schedule it over the 8th and 9th, either remotely or in person. Obviously, we have fewer in-person seats, but a lot fewer requests. And then you would likely be sitting next to someone taking a different test.
Okay, so perhaps we can watch. We couldn't watch, but there might be other folks there doing other things.
Oh yeah, I mean, I think in terms of what the people who are proctoring the test would like is for you not to watch very close, but you could probably, because what Robbie did and the staff that went out to visit too, there are test takers there all the time at these sites. You can kind of walk around quietly, and then you wouldn't be able to really do anything very active if there are a lot of different tests being administered.
Okay, thank you.
So if the purpose is to test the abilities of the vendor to provide us with a secure, non-stressful testing environment for the February exam, I think it would be short-sighted to limit the number of facilities. We want to give this, we're basically handing off our function to this vendor. And so I think we want to give it a good stress test. It's always troubled me when senior bar staff is having to go out and staff bar exams. First of all, that's very expensive at their hourly rates, but also it's taking them away from their other duties, which presumably aren't aren't filled in by others. So if it is our intention to offload the function of giving the test to this vendor, I think we want to stress the whole system and see if it's up to it. Because if it isn't, learning in February that it isn't would be stressful, to say the least.
We can answer that. Bridget?
Yeah, sure. I just want, oh, sorry, was somebody saying something?
I just had a little bit to add, but Bridget, you go ahead first.
Sure. I just want to say, I appreciate this. I think really what this is about, Robbie, to your point, is quality control, right? And this is an unknown for us because it's a new vendor and a new way of doing things. So to us, we've been negotiating with Measure, and we'll keep you more specifically in the loop, Robbie, as we continue our contract negotiations. We are working really hard to put very specific requirements for test centers right and hardwired into the contract for all the reasons that you're stating. It's very important to us that the test takers have the same experience, a uniform test taking experience. We also don't exactly know yet how many people are going to preference to do in person or not. We're making this transition, and from my perspective, I think it's important to the extent possible to at least plan to have as many in-person available sites as possible as we're starting this. I believe, as you suggest, that as people get more comfortable or they see the way that this online test is working, more and more people will opt into the online administration of the exam. We don't know. We are projecting that, but we don't know. But especially for this first one, we're trying to negotiate as many open sites as possible to accommodate people that might still not be ready to take it remotely for the reasons that people have described. So what I just want to assure you is, as we work in the contracting process, we are making sure that our standards are hardwired in there. And then also, I do think you raise an important point, at least about quality control. And from staff standpoint, we'll see what we can do to at least go visit the sites and see what they are. I don't know if we'll all be able to be dispatched at the same time while the exam is going on, but at a minimum, like I know I visited a site in San Diego, and I thought it was very professionally run. They had all the standards. They showed me all the things that they had, the loggers and the way that it all worked, and it was going well. So that type of thing where we can go to visit the different places where it might be located and understand for ourselves what types of standards they have, I think will be important going forward.
And this is Robbie. Thank you, Bridget, and CBE members. I keep coming back to this because Bridget visited a Measure Learning contracted site in San Diego and had an excellent experience. I visited their LA Koreatown site and had a very, very negative experience, which I've shared with bar staff. So it's a mixed bag.
Well, and sorry to interrupt you. I do want to tell you that I know you've spoken with Measure and we have too shared your concerns. So I do think that's important to the extent we go to the places, we learn about the concerns we have, make sure they can either address them at that individual site or, to your point, perhaps not use that particular site once we go. So but I do want to assure you that we are taking those concerns that you've raised seriously, and I know Measure is too. So that can help with this customer, quality control endeavor.
And Judge Rayner, you were so right. When I visited the LA site, there were a number of different, the notary exam, and there were a number of different exams being administered, not only by Measure Learning, but by another similar company that also rented space at the site that I visited that was also administering exams. So, and Measure Learning, I just have to say, no one at Measure Learning has ever been to the site that I visited. I have, but none of them have. Because they're big and they contracted it and they did listen to my concerns. They've actually never been there, which is why I wanted, one of us to be there. And I'm going to stop. I just will ask Audrey, Bridget, Amy, please keep me in the loop. I will be responsive to any needs and visit. I really want to make sure that this works out because, as I've said many times, the way the state bar does it is just amazing and awesome. And I'm sorry that for lots of reasons, we're not going to be doing that anymore. And I just want to make sure that no applicant receives a lesser experience than what we've been offering since I've been on the CBE, and this is my 9th year. So just keep me posted and don't be afraid to reach out to me and to Alex Brody Chan.
Thank you, Robbie. Your feedback has been really helpful so far. And again, thank you for volunteering to help with us.
Yeah, thanks, Chan Brody. I do have to echo though. I think it is very important, and I think Paul Kramer alluded to this. I think we should take advantage of this opportunity. If we can do a stress test, I would like to see how the system operates as a whole. And to the extent we're limiting, the test centers, I don't know if we should, because I think right now we don't have any indicators that they can potentially accommodate the capacity that we have. They say they do, but I certainly want to see the results. So I don't know. What limitations there are with respect to this experiment. I want to ask that Chan Brody over here to just continue to provide your oversight and keep us posted. And I will obviously be looked into this, but I would like to see whether this is going to be a successful experiment for all. But there's one thing that I wanted to mention. I know we didn't get to mention this, but I think it's worth mentioning here. Now, I know at the last meeting we talked about financial incentives. And obviously provided, funding is there that we could potentially provide some financial incentive in addition to the points credit that we have talked about. Have we explored that option? If so, where are things in terms of that discussion?
I think that the idea of a financial incentive might be more tied to the phase 2 of the experiment. There's not a financial incentive tied to the November 8th and 9th test, but it has no cost. So it's
Got it. Yep. So it's the second one where we will have to incur costs. And so it sounds like maybe for the benefit of the CB. So it sounds like we're going to have another experiment for the July applicants next year. Is that right, Audrey?
Right. But
And then
can I
obviously, yeah, absolutely, Ms. Nolan.
clarify
Go
one
ahead.
thing? So the phase 1, we're incurring costs, the measured learning costs, but that's being funded by the state bar.
And there's no cost to the applicant is what I meant. So,
Okay.
to the person, there's no cost at all.
And so does that mean the one next year there will be a cost associated with the experiment?
Well, it's going to
to the
be
applicant?
in conjunction with the July bar exam. So the people who register and, there's a fee associated with that, have the
Right.
option of selecting into this experiment.
I see. Do you have a timeline as far as when the registration will open, when it will close? And this is for the next year, July administration. And then the experiment will take place.
Yes,
I mean,
I'm sure Becky has these all memorized. The July bar exam always opens March 1st. And then there are several deadlines in terms of filing, late fee deadlines, and then a timely filing deadline that I don't have that off the top of my head when that is in June or July. It's probably the beginning of July. No, it's not, because no, maybe it is. Becky will have to correct me when the final filing deadline is for the July bar exam, but I know it opens March 1st.
But the experiment will be when?
Well, we're kind of thinking about it as like a third day. So
Mhm.
it'll be, concurrent with taking the 2 days of the bar exam.
Okay.
Guess I'm sure we'll discuss more in detail.
Yeah. Yes, I think that we will. And we're still waiting, as you know, for that order to come back on the experiment.
Well, we need to get through our agenda. So unless we
Yes,
have
okay.
any other comments from anyone else, we do have a motion. And I would ask that either
Actually,
Devin or I read the motion.
We
Go
haven't
ahead.
finished covering everything on our updates.
I'm
I want
sorry.
to update everybody. Oh yeah, no problem. We're on the wrong screen. So if maybe you could advance like a couple of screens. I want to provide an update on the February 2025 bar exam application. And I'm also going to invite a guest that's coming from our lawyer assistance program. But before I do that, I want to let everybody know that we successfully opened the exam application for the February 2025 exam on October 1st. That application opened with an option for applicants to elect the modality in which they want to take the exam between in-person at a test center or remote, with the caveat that the modality is contingent on Supreme Court approval to be able to provide this exam in both modalities. So applicants were made aware that their preference is not guaranteed. As of today, we have 740 applicants that have applied so far. The bar exam FAQs will be updated with up-to-date information as plans progress. And that will involve notifying applicants that have already registered about any changes, updating our web pages, and revising our FAQs as soon as upon a decision by the Supreme Court. For this exam, we're also offering the bar exam strategies and stories program once more, recognizing the support that this program brings to participating applicants. And today we're inviting Ken Norse, who is in our audience. It's going to be come in as a panelist. He's a senior program analyst from Lawyer Assistance Program, and he's here to describe other support programs that are being offered through his office. So with that, I'm going to hand this over to Ken Norse.
Thank you so much, Amy. It's a pleasure to be presenting to you. You know, part of the remit of the Lawyers Assistance Program is not only to help attorneys and law students, but also bar applicants. And I wanted to talk about some wraparound programming that we have through the Lawyer Assistance Program that does further that mission as well. First of all, I need to let everyone know that 12.5% of attorneys have ADHD. And when we were surveying many different groups that we support, there was a strong demand for ADHD programming, and that's not only limited to attorneys and law students, but bar applicants as well. And so I recently developed a pilot program for ADHD programming. It's called Reset ADHD Strategies for Success in Law. We just completed our third week of programming. We had to limit registrations to 1,350, and I was actually shocked when that limit was reached within 48 hours. So we know that there's huge demand for this programming. It focuses on various executive functioning elements that are a component of ADHD, such as motivational regulation, working memory, emotional regulation, planning and problem solving, inhibition and impulse control, and self-awareness. We will be debriefing this pilot, and I expect to have further ADHD-related programming in the new year. Next, I'd like to talk about an Office of Professional Competence toolbox that was created, Overcoming Imposter Syndrome. This is a series of resources for attorneys, law students, and employers, and it is available on the State Bar website. Probably easiest to just search for Overcoming Imposter Syndrome there. And then I'd like to turn next to a specific program that was developed for bar applicants, and that's the Reset Bar Retaker Support Program. When looking at our lab programming, we wanted to expand bar applicant programming, and it was really clear to me from the data that bar retakers especially needed assistance. A bar retaker's prior failed attempt is really the strongest predictor of a future failure. And we realized that we wanted to bring in experts to provide both mental health support as well as study skills focused support. The objectives were really to expand support for bar exam applicants, as I mentioned. We also wanted to help promote access to the legal profession through this program. This program really does, just due to the data behind retakers, supports underrepresented groups such as first-generation law students and historically marginalized groups, all of whom are overrepresented in retakers. And then we also wanted to complement existing programs such as the Strategies and Stories program. That program is asynchronous, so we wanted to develop a live interactive program that combined not only mental health related skills, but also study skills for retakers. So I'd like to talk next about the July pilot that I ran. We supported between 115 and 176 retakers per session. We had a total of, from the best of my ability to divine this, 279 total unique attendees. That's actually a small percentage of retakers, and we're hoping to dramatically increase that. I'll talk about that during the Feb program. We had 4 sessions, the first and fourth of which focused solely on mental health related skills, and the second and third were focused on study skills. We did see a positive impact based on evaluations, although for the pilot, the evaluation response rate was only between 10 to 20%. The evaluations did indicate that retakers who participated felt that they had improved their mental and study skills. We had engagement through an interactive question and answer session that did allow for some participant engagement. Unfortunately, just due to the large numbers, it's difficult to have a seminar style. So I am just getting ready to launch our February 2025 General Bar Exam Reset program. We are expecting increased participation through expanded cross-promotion by law schools. I do present to the law school committee and CS bars as well on this. We are expanding from 4 to 5 sessions and going from 60 to 90 minutes to allow for increase in content. And this time, rather than have separate mental health sessions, we're going to interleaf the mental health skills with the study skills, so we don't have lower attendance during mental health sessions. And in order to determine our impact, we are going to be issuing redesigned program evaluations prior to the end of each session. And it's something that I piloted with our ADHD programming. We're getting almost 100% results from our survey as a result of that. And then we'd also like to start building a library of pre-recorded material that can be used for many different things, including asynchronous content engagement by retakers. So that completes my overview of the Reset program and a few other wraparound programming that we have through LAP that are directly applicable to bar applicants.
Great. Thank you so much, Ken. I guess this is a good segue into the second component of today's discussion, which is an action related to remote or test center administration for test takers outside of California. Just to quickly reference the earlier sentiment by some of the members, this was a topic that was briefly raised at the October 30th CBE meeting, and staff determined that we should quickly turn around and bring this issue back to the committee for formal determination. So we are going to tee up just a quick explanation of the issue at hand, and then I think we can turn to the resolution as the chair was alluding to. So let me quickly cover this topic. So today we're going to seek action again from the Committee on Remote or Test Center Administration for those test takers outside of California. We believe that this issue can be distilled into 2 important considerations. One, requiring applicants to travel to California is a large burden, and we'll be sharing some data on that both now and in a later presentation. And 2, while the risk of remote or test center administration outside of California is essentially no different than it is remotely or at a test center within the state. So I want to just provide some data I think that can help inform this discussion, and then we can move to the resolution. But in February and July of 2024, we found that 22% and 20% of approved bar exam applications were from applicants with out-of-state addresses. So that helps us get a sense of the scope of this discussion. When staff recommended the proposed changes beginning with the February 2025 bar exam, one of the big benefits that we believe is reducing costs and burden for applicants. And we're going to dive into this more later today, but we found in our July 2024 bar exam post-exam survey that 1/3 of test takers that responded to the survey spent over $1,000 in travel and lodging for the exam. And then we found that 1/4 traveled over 250 miles from their residence to the test center of their choice. So we feel that the data shows that the expense and logistical burden is quite large if we require applicants to travel to the state when we now have an approach that can make it more convenient and less costly. I'm not going to dive too much into the details, but at the September 30th meeting, we had Measure Learning come and speak to the committee, and they shared a lot about their global exam administration experience. And they also listed some of the security measures that are in place. And they talked about the secure browser, remote access detection, meaning if someone's accessing another person's laptop, that can be detected. A little bit about their ID check and proctor process, and a few other systems that they have in place. We want to list them here and remind the committee that these systems are essentially the same regardless of the location of the individual test taker. So again, those two considerations we believe are most important: the burden on applicants and the risk to the exam. And with that, I'll just reiterate what our recommendations are for today's action. Staff asks that the committee approve that applicants outside of California be allowed to take the bar exam remotely, that applicants outside of California also be allowed to take the bar exam at a test center near them outside of California, and also be asked that participants in both phase 1 and phase 2 of the California bar exam experiment be allowed to do the same. So with that, I know we're eager to get to the resolution, but happy to take any questions before we do that.
To be clear, this should allow global test taking, right? Not just in the United States.
I think we feel that again continues that pattern of reducing burden and cost. Certainly, those burdens and costs are even higher for our international applicants. But perhaps that's part of the discussion today that the committee can consider.
Okay, yeah, I'm okay with global taking, but I think we should be maybe a little more clear in the actual language so that there's no doubt, whichever we decide.
Sure, and I think I would reiterate, Paul, to that point, the idea that the security systems in place remain the same regardless of that location of the test taker, and that is the same whether they're in another state or in another country.
I think Paul might be saying the resolution language. I guess maybe when we get to that part. Okay.
Yep, certainly.
This is Robbie. Is this when we talk about how we feel about this, or this is just the question time? Gosh, I'm being such a troublemaker today. I'm like the Paul Kramer of the LA office, and I usually agree with Paul, but I don't today. I'm just going to go ahead and say, CBE members, I am against diluting what we do at the state bar even more. I think that applicants that want to take the California bar exam should come to California to take it, to preserve the integrity of the exam that we administer. I mean, I'm guessing, I haven't seen the numbers, but I'm guessing that this number is super small anyway, of people that do it. But I guess, because it's come up at prior bar exams, I've been looking at Reddit, and questions that are on the bar exam are discussed on Reddit within 1 minute of the exam ending. And if we're talking about different time zones, applicants are, the integrity of the exam here in California, I think I can stand by, certainly while the bar's been administering it. But if we're talking about time zones where the bar is over in California and is being discussed to the most minute degree, people have incredible memories and they reproduce the questions. I'm talking about within a minute of the exam being over. I just think we lose control. And to Paul's point, I disagree that we should have lots of test centers. I think we should have as few as possible, just like when we administer the bar. There's going to be one place to take the bar in San Diego. Let's pick them. And certainly if we're going out of state, then we really don't know what's going on. And if someone wants to take the exam in person somewhere else, a site that maybe we haven't visited, I just think that we lose too much control over administering of such a high stakes exam. I think the burden on applicants to come here to take the exam is well outweighed by the benefit that applicant gets. One, from taking in our secure environment, and two, passing the California bar exam. This is a state exam. I have no problem with the requirement that you come here for the 2 days to take the exam. So no offense, but I am opposed to outside of the state administration of the exam. And now I will shut up.
Robbie, do you mean someone who's taking it remotely would have to drive to California to take it remotely?
Yes, they would have to take the exam here in our state. I don't know, maybe I'm being a Rip Van Winkle about it, but gosh, I mean, you know, what if an applicant says, okay, I'm going to go to a state with a different time zone, so I'll see the whole exam before I take it?
Well, no, my assumption is that if you're taking this on the other side of the world, you're going to be taking it in the middle of the night in our time, the same time as others.
Yeah, I think that's an important thing. Thank you, Paul. I think the remote administration of the exam can be done on our time zone. So everyone
but we don't know if machine learning would be available. That is, I don't know their open hours,
we
right?
do,
If you
'cause
have,
we've been talking to them about the experiment, and they remotely, it's in-person centers where there's people who wake up and open up a center, right? Those hours are different. Remotely, they have a 24/7 remote capability.
for test centers, I think the concern is, do we know the operating hours for these test centers?
At least I think they were saying, at least the ones we were talking about for the experiment, I think it was 9 to 5.
Okay, so if you're, for example, in Hawaii, right, taking the bar, or in New York taking the bar, you would have to sync up your time zone, provided that they're still open at 5 p.m. local time, right? Is it 5 p.m. local time, or is this specific?
Yeah, so right, it would imagine like someone opening up an office, right? So it would be kind of that kind of business hours. And so that could be something the committee thinks about in terms of the remote versus test center choices.
This is probably a logistical issue, because if you have an applicant taking the bar in New York 3 hours ahead of California, that would be, let's say, you know, if we start the exam at 9, that would be noon over there. And so that would only give the applicant 5 hours before the closing hours of 5 local time over there to take the exam. That's nearly impossible.
Right,
But I will.
I'm sorry.
Not so much for an all-day bar exam, though.
I mean, I have other concerns, but it looks like Bethany has her hands up. So let's give her some time.
Thank you, Mr. Chair. I just wanted to chime in. You know, I am generally in favor of moving to a remote bar exam for the reasons that we're doing it. But I do just want to state that I share Robbie's concerns about, you know, having an expansive amount of test centers. I won't repeat his reasons because I agree with every single one of them. I also just wanted to note in terms of this, you know, time zone discussion we're having. Thank you, Audrey, for noting that, you know, we were going to do it on Pacific time zone. But I want to remind us too that we have the testing accommodations applicants, where some of those individuals are taking the exam over longer periods of time than the non-testing accommodation applicants. And so for those people, the issues Robbie raised about, you know, people getting this bar exam questions and posting them, because we know that's what people do. And we know there are many people that show up at the bar just to get the questions, not really to be licensed. And so for those people taking the bar exam longer, they could possibly still have the opportunity to see what some of the questions are before they complete their exam. Also, just something else I'm thinking about regarding the number of the test centers. You know, I haven't been to any of the Measure Learning facilities, and I do plan to try to attend the sample in November, but I have been to some of these centers for, you know, other exams like the MPRE. And I do know, as Robbie has noted, that there is varying quality of the test centers. And I know that we always get, you know, complaints and concerns after the bar exam at our own centers, right? From people saying like, oh, there was so much traffic outside, or there was an earthquake here, or somebody was, sneezing outside the window where I'm taking the exam. And so I imagine that if we're going to have all of these test centers, staff is going to be inundated with a lot of similar complaints like that. And so I'm not against remote testing, but I do just think that it's good that we're talking about these things to work them out. But for the record, I share Robbie's concerns.
Sorry, Alex, I just want to note that the LA site just went out. So they need to get back online, which is several members. We still have quorum, but that is several members that need to get back. The power went out in that room apparently, but IT is there.
Did we pay the bills? State Bar paid the bills, I hope.
A good one. In terms of the testing accommodation extended days, we have that same situation now, obviously, right? People test over extended days after the material has been concluded for the standard 2-day test. We have that consideration now. Even now with the multi-state bar exam, someone starts it in New York, right? With the same question set, and then we're taking it hours later. So some of those things are not so dissimilar.
Look, there are a lot of issues. Like I said, I think the time zone issue is an important one. You have people taking it at noon, their time in New York, for example, or even in Honolulu at 6 a.m. in the morning, right? Just to sync up our time zone. There's going to be a lot of issues, but I do.
LA's back, by the way.
Welcome, folks. We unanimously voted that you guys would be buying us lunch next time, so thank you. But here's really my general concern. My concern, and I want to echo what Robbie said, and I do agree also with my brother Kramer about what he said. I think we ultimately need to expand the availability of these testing locations to as many sites as possible. I think just because measured learning has limited capacity in California, I'm just concerned that they may not be able to accommodate all 7,000 applicants in July. Or, obviously that number may be a lot smaller because you have applicants that are doing it remotely at their own home. Great. But there are individuals who don't have that capability, whether it's an internet issue, or maybe they just don't have an environment in which to take the bar exam. And so I just want to make sure we do have places where people can come in and take the exam in person. And so now with that said, I really don't know whether they still have the capability that they advocate that they do have. Now, I haven't seen any evidence. I can only say, yes, they probably have the capability to monitor and proctor the exam in the way that they have advertised. There's no reason to doubt. But until I see solid, concrete evidence that they have the ability to do that, and that we don't have any issues like what Robbie has experienced at the testing center, I remain somewhat skeptical. And this skepticism, again, comes from the fact that it's not just Robbie. I've certainly had heard or received that criticism from other individuals. And so until we, are able to fine tune and perfect testing centers and the environment, in which the applicants can take the bar exam, I'm just worried that if we were to do it outside the state, that gives us very limited resources to fix anything outside of the state. And so again, Robbie is right, but Paul is also correct. And so I'm somewhere in the middle. But like I said, until I want to take baby steps. I think we'll get there. And Paul is right. We'll get there. But I think I think it's important not to run before we learn how to walk. And so with that, I think Robbie, I go with your sentiment.
Hey, everybody, thanks very much for indulging. I guess I would end my comments by saying, how about if we focus with measure learning and California administration now and table this for after an experiment and after the February bar, then maybe in the future we can talk about out of state administration. I mean, currently on this proposal, I'm afraid I'm not there, but I'm not saying I'm not going to be, old man about that. I'm not there forever, but I'm not there today. And thanks everyone.
You're not old by any stretch of imagination, but I know the staff would appreciate, giving them the heads up now versus later, because I know they have stuff to do. If they do vote that they can do it out of state, I'm sure there, a separate process to make it happen. If we vote against it, then they can focus on only California. So I think they want an answer, right, Audrey? Would you agree?
Yeah,
that you want us to
be really
decide
clear.
today?
Yeah, so Amy's been trying furiously to update all the FAQs, right? Because there's so much going on. Any clarity we can give to applicants, and I think, there's probably some of them watching this meeting, right? And I would just have everyone think about if someone's remotely taking the test on our Pacific time, even if they're in Florida, are we saying that we really want that person to drive to California and get a hotel room to take a remote test? That is just something I want everyone to think about in terms of the resolution.
Thank you, Audrey.
Audrey, and again, I just want to try to put this in perspective because I think this number is like super
It's not
small.
though, if you saw, not that small. So 20 to 22% from Cody's analysis of zip codes, right? So, you know, people now.
And is
I mean, I know a lot of, law firms on the East Coast, they pay for their lawyers to get licensed here and they fly them out to take the exam. They provide the form prep
That
there.
sounds like something that can't possibly be everyone's experience. That could be a privileged experience.
Yeah, you're talking about the privileged few, or the Robbie. Neither of us is in the boat where we have obnoxious roommates, uncontrollable cats, or God knows what else, noisy neighbors. I'm going to admit that I'm a boomer, but also I'm just not. I don't have the problem, but I recognize that some people do. I have a question though. Is it possible to determine if somebody is remotely accessing from within the state?
Yeah, you can determine that through IP address.
Even through VPN?
Yeah, but they could VPN into the state.
Is that I think that's something that with their Guardian browser, you're not allowed to VPN.
Yes. Yeah.
Okay.
Do we know for the experiment testers on November 8th and 9th, any idea how many are planning to take it remotely from a different state?
We'd have to look and see at their address and zip code they have with us, but there are going to be, because that pool is quite large now, right? 4,500, maybe more today. There will be folks who want to remotely take that test. Again, that's a 90-minute multiple choice test. They would definitely prefer, if they're in Nevada or Arizona, Texas, Florida, to take that remotely and not to drive to California, rent a hotel room to take a remote exam.
And I would say, even if you feel like the real bar, the February and July bar exams should be taken within the state, I don't know that those same concerns apply equally to this test.
Yeah, I was wondering if we can let the November 8th and 9th one, I don't know.
Yeah,
I might have any reservations if
test
being done in the state.
other aspects of the, the whole program.
Yes, I mean, I think this is why we're having the discussion. We can redraft the resolution to focus on the 8th and 9th, and then talk about the bar exam and break that up to talk about remote versus test center. That's, we can make a lot of modifications on the resolution today. But I think the clarity is really helpful for the test takers.
But for the sake of test takers for February, they really need to know pretty soon what they're going to have to do, because they may decide to, well, I can't do it in February if I have to travel.
Cody, a clarifying question for you. When you say 20 or 22%, is that based on the number of respondents responding to the survey, or is that for all the bar exam applicants? I didn't catch the number or the basis, so.
Yeah, that's a good point. That 20 or 25% was approved applications for the February and July exam. So even amongst that population, some ultimately don't take the exam, but we prepare a lot of our preparations for the exam based on the number of approved applications.
Right. So how many, what number are we looking at here instead of looking at percentages?
What's the N? What was the N that you did for the?
You know what? I don't have that right in front of me, but I can put that together. Give me 1 second.
And when we say approved application, you mean those who met the eligibility, pay their dues, and then be ready to take the bar? So
yep,
example,
they submitted an application, they were approved, they could have sat for the application, they could have sat for the exam. Some small portion of them ultimately don't
So
take
he
the
didn't
exam.
look at like no shows, right? So looking at the February bar exams, July bar exams, who were approved, who we thought were going to come sit for the exam.
But those numbers would be negligible, would be really small. It wouldn't affect the overall percentages, not in a substantive manner. But I'm guessing that we're looking like 7,000, like 20% of 7,000 applicants, or
Well,
or
for
what
February
am
and July, it's usually more like 13,000, right? So the combined.
Yeah, I don't have the end for the approved applications in front of me. And it's loading slowly, but I could just tell you if that trend bore out for the actual test taker population for February 2024, you're looking at about 850 individuals. And for July, just doing some quick scratch math here.
You did your math, Cody. Judge Reno?
Yeah, no, I'm slightly different, but I'm just thinking about the November 8th and 9th tests. I mean, I think part of, I recall us doing this was we wanted to make sure we got the maximum number of applicants to test our new questions. So I kind of feel that, in my opinion, we should allow the test for out of state. I don't know how many applicants that are, but because that was a big worry, at least as I recall. You know, whether or not we do it in February, I share some of the concerns that have been raised, but I at least think part of the resolution was the November 8th and 9th, and February and going forward, I think maybe my vote might be to allow for the November 8th and 9th to be done out of state.
And this is Robbie, Judge Reyna. Well, Audrey, do you know, because it sounds like we have enough applicants for the 8th and 9th test. We have enough people that have signed up. Do we know if any of them want to take it from out of state?
Oh, I'm assuming yes, it's a large pool. So we're still accepting applications. What I don't have is the number of those folks who are going. A lot of them are 3Ls, so a number of who are at law schools outside of California. But I'm assuming that there will be a percent. I don't know if it's as high as 20%, but there will be people who want to take that remotely from where they are.
I'm just gonna say that, you know, I have such respect for the state bar. I've been volunteering with the bar for a long time, and I just recommend baby steps with giving up what we do and what we do so well. This is the first time we're not doing the bar ourselves. Let's take it one step at a time and stick with in-state. It sounds like we have more than enough applicants for our test without stretching what we're doing. I
would say if we're kind of like parsing out the motion and talking about the experiment and then about the bar exam, you would want to exclude from the applicant pool now to deny folks who are out of state and wanting to test.
I don't think we need to change the motion.
I have a question.
Vote to deny for now. This can be for another day. Let's see if Measure Learning can deliver for us in-state administration of the exam the way we've always done it. Let's see if they can do what we do so well. That's what I want to see. Other ideas, far-flung ideas for a non-boomer, let's save that for another day. Let's try this first.
I have a question and a statement.
Go ahead, I'm all done. Thanks,
Okay,
Larry.
statement is, remember why we're doing this, because we're broke. Okay. The question is, has anyone, staff, I guess, looked at the equity access issues that are embedded in this conversation about out-of-state remote takers, as well as in-state?
Well, maybe I can jump in. With regard to equity and access, I think we have been introducing more opportunities to measure that. You know, we presented as part of teeing up this discussion some of the cost and travel limitations. Later today, we'll discuss some of the survey findings in more detail. I guess I'm not clear as far as what other ways you're thinking about measuring that access issue. I think we've looked at it mostly as a cost limitation. We will frame a discussion later, some of the technological limitations, which are pretty minor and minimal for most test takers. But are you thinking of other challenges that we should be bringing to the discussion?
You know, I don't know how to measure it because that's not my job, but, you know, I know that the bars, you know, one of the overarching goals of the bar is to diversify the legal profession in the state of California. And so everything we do, from how we do discipline, how we do admittance, how we do moral character, how we do the testing, how we supervise law schools, that has to be viewed through that lens. That has to be a piece of it. You know, now everyone is different. It's nuanced, so every area is going to be dealt with differently, but we can't lose sight of the fact that that's an overarching goal of the bar, because it's an overarching goal of the body politic and the people of California.
Allowing
So that's
test
why I
takers-
bring it up.
Allowing test takers to test outside of California would remove a barrier, right? Because there is an economic barrier to
Right.
coming to California. So I think
Right.
that answered, and Cody did have that, the dollar amounts on the slide. So I think that
Yeah.
answered you.
I don't honestly, I don't think Brody Chan here is recommending that we don't go with that approach. I think he's just more cautious in terms of making sure everything runs smoothly before expanding it nationwide. I think that's sort of the gist that I get from Chan Brody here. Is that correct?
Yes, that's right. Baby steps. This is a big, we're giving up something that we are great at. Amy
Personally-
Nunez is amazing, and you know, not going to be
Thank you,
Amy
Larry.
Nunez anymore.
Right, and thank you, Larry. I'm with you. I think it's very important not to lose sight on the DEI initiatives, and this is going to be a very important way to make it happen. But it wouldn't do anyone any good if it fails. Meaning, if somehow those testing centers don't do what they, you know, what we will inform that they would do. I think that's really just a concern, making sure we have everything lined up to make this a successful journey going forward. Bridget, looks like you have your hand raised.
Sure. Yes, I would say the concerns that I'm hearing, maybe it would be worth talking about splitting this up a little bit, right? Because from a remote standpoint, first of all, I haven't heard, I mean, as you've all known, you know, Measure Learning, this is what they do everywhere across the globe. So I don't think the exam taker experience is going to be any different remotely, whether you're taking it sitting in San Diego or sitting in Florida, to Audrey's point. I haven't heard, you know, assuming that everybody is taking it during the same testing window, I don't really see how that is going to be any different from a administration standpoint, or, you know, a baby step standpoint, limiting, making people like drive somewhere to log into their computer. I don't really think is it operationally any different. I think the issue about out of state or out of the country test centers, you know, with the time zone issue, is something that's a little bit different. So I just want to make sure we're all on the same page, or you're all on the same page as far as that type of discussion and thinking about how to limit the out of state portion. But I will say again, with Measure Learning, this is something that they do all the time, that they know, you know, and that we're building into the contract negotiations, all the data security, all of these types of things. So as long as it's still within the same testing window, I'm not sure the exam administration would be any different if we're limiting where people are physically logging in.
Well, and Bridget, maybe I can add to that just to provide two more examples. I think you're describing, Bridget, the example of someone who comes to the state of California and then ultimately sits for the exam remotely in California. We're talking about, I think, the more obvious example of someone who's traveling from Florida or something. But at face, it's hard to explain a scenario in which someone who lives in Reno, Nevada, has to drive just across the border to go to a hotel and log in. So if we're saying that remote option for out of state is available, I find that hard to maybe perhaps explain the situation. To go back to Larry's comment about access, if the message is actually that if you come from out of state, you have to test in a test center, we're now putting, I think, a real burden on the test centers, which we, I think at this point, imagine will be provided to those who list that as a preference. And I think we imagine that those preferences will be listed by people who have lack of access to a stable internet access, or the type of distracting environment that Paul mentioned earlier. And so I don't think we can measure that at this point, but talking about access to the exam, I think preserving as much space in test centers for those who need it is definitely one of the goals that we would like to achieve with this model.
And I just want to add another thought to this conversation, and that is during the pandemic, we had 3 separate remote bar exams. So we had the July bar exam that 2020 that became the October, and then the 2 exams in 2021. And we had a different vendor at that time, but we tried to apply the same security standards and also the standards of what, allowable items and so on that we have now into that exam. And we had applicants that tested internationally and out of state. And I know that was a pandemic and that was a big consideration, but through our proctoring and we were able to ensure that cheating incidents or any, whatever the concern might be here, weren't happening. I think that we had the same rules in place in terms of the VPN, not being able to use VPN, also the external monitors. We had security measures in place that we're hoping to address all of those issues. And I think through our remote proctoring, we were able to detect whether any of that happened. And when we came to measured learning, I think, or any of the vendors that we vetted for this process, is that we were looking with using the same scrutiny in terms of the security measures that we wanted to have in place. So that's just something I want to point out, that we never, I guess, denied anybody to sit from another state or another country during those exams. And here, in terms of also the test centers, we also factored in the availability of test centers outside of California and also the country when we were looking at vendors, because we thought that would be beneficial to our applicants. And so, I feel like we have this service available to us and we're like choosing not to use it. And I totally understand that it might, this might be all about security or moving too quickly, but I just don't want to lose sight of like the fact that these are things that we factored into the selection process or in the vetting process, but also that, we could baby step. I think what I would recommend, and just as we're putting this together, is maybe allow some of this to happen in February, perhaps maybe not out of country. Let's say we said people could test from out of state and measure some of the concerns that, and assess some of the concerns that are being expressed here today. And it sounds like quality of the exam administration altogether is one of those, and then security factors. And this is live remote proctoring, but it's being recorded, so we can assess for those 2 things in that process. So it also mentioned that we're going to have a survey at the end of this, so we'll hear from applicants themselves. But I just think that there's a way that we could test in November and learn quickly, so we can apply this to February and not, lose sight of the fact that the availability of test centers outside of California it could be beneficial to our applicants.
What I'm thinking is, can we perhaps, it sounds like we're going to have a survey, right, for the experiment. After the experiment, applicants will take a survey about the experiment experience. Am I right, Audrey and Amy?
Yes.
Yep.
Okay, so that would be very informative. I think I would certainly like to see what the outcome would be. Now, at that time, am I right that it would be too late for the committee to inform the state bar which direction to take? Or is there still enough time after looking at the survey to be able to make an informed decision on how to approach this issue?
In terms of applicants deciding if they're going to take the
For the
February,
February,
I mean,
I know, the
think about the
registration.
mindset of the person, I would say. Yeah.
Absolutely, absolutely. Nothing is. I agree with you. There are a lot of there's some concerns as well. When are we opening the registration process for the February bar exam? It's open right now,
It
right?
opened, yep, exactly, October 1st.
Yeah, right. And obviously some of them will be taking the experiment. Um, Personally, I would love to have another meeting after the experiment, after we have gathered the survey data, even if that's not the norm. I know we have a meeting scheduled for December, and if that's too late, I would certainly be asking to have a internal or a CBE meeting that would happen sooner, just for this specific agenda item and for the benefit of the applicants. And so again, I'm not taking the position. I'm just trying to think of, if there's any common ground in the middle ground we could take that could, merge the issues that everyone has and also other resolutions at hand. But am I right, Audrey, that potentially one possible solution would be to look at the results, call a meeting in November, and then to make an informed decision? And at that time, would there still be enough time, do you think, for applicants to make an informed decision whether they'll be flying in or driving? I honestly, it hurts me if someone were to drive to Florida. I mean, that's a crazy drive, and I would never, phantom
I
anyone
only
would be driving.
picked Florida because I think we had a public comment at our last meeting about that very scenario.
Yeah, and I don't doubt that. I'm sure there are applicants who are like this, for the sake of economics and for whatever reason. There are applicants. But that being said, I'm trying to think if there will be still enough time. It looks like Kara have a question. Maybe you can help answer that question.
So maybe not answering for you, but just another thing to consider is that if you do wait until after the experiment, these applicants are going to be subject to late fees because the timely filing deadline is November 1st. So between November 2nd and 29th, it's $50. From November 30th to the January 1st, it goes up to $250. And since we've been discussing, the overall cost of the exam, that's pretty significant.
Right, but am I right? At least the applicants would still be able to take the exam at home, meaning not all 20%. At least I don't think that's the expectation, that the 20 or 22% number that we have, everyone would be driving, right? That there's some percentage of that percentage, or 850 applicants would be doing it at home, right?
If you allow for remote testing outside of California, then they will be able to do it at home.
Right.
Yeah,
Okay.
so that depends on how we vote today.
All right, folks, I know we've been on this issue for quite some time, so I think we need to make a decision on how we, tackle this resolution. I know we have one on the screen. I don't know if Audrey or Amy can put it up just so that the community can see the motion.
I think was Cody going to put it up, because we're probably going to have to do a lot of editing. If not, I can get it up.
Okay.
I can put that up. Just 1 second here.
Just out of curiosity, Robbie, are you okay with the November 8th and 9th being tested out of state?
I think we have plenty of applicants that we can limit this baby stepwise in-state. I think we have more applicants than we can use. So yeah, and Cody, you never came up with these numbers about out of state. Maybe you could do that. And I'm not really even sure what numbers you were talking about, numbers of people that were wanted to take the exam from out of state, because we haven't done that in a regular bar exam. So I'm not sure, what was the end that you said you couldn't pull up? Seems just like we're not ready.
Yeah, so we looked at the number of applicants who submitted an application for the bar exam who were approved. So this is the entire pool of individuals who could have shown up to a test center and sat for the exam. We have on file, as far as our applicant record, their address on file. And that's our best sense of where they're currently located. So
applicants that maybe go to school, that live here in California, but go to school out of state, that would come home to take the bar exam, you're looking at their address. I just don't know where you got 20% of bar applicants that would want to take the exam from another state. I've never heard that in all these years.
Who travel to take, but that people travel to California to get licensed.
Okay, I don't want to waste any more time, but Judge.
Sorry, can I just clarify one quick thing? Robbie, the data that Cody put together was based on people's home address zip code, not on where people are taking it now, because everybody has to come in state.
Right. So
Okay.
Judge, my answer is, I'm not, okay, I'm gonna vote no on the motion that Cody says that they're gonna put on the screen that says remotely or at test centers in locations outside the state for this. I just.
Cody, can you
this is
can you put it up again?
Yeah, so
if
there's
you-
the resolution, and I should note that this was a track change added in
Can you make it
anticipation
larger?
of
Sorry,
the.
you can't
Oh, I apologize. Let me get rid of that. And let me zoom in for everyone. There you go. I just want to note that this track change was added to better reflect the recommendation related to the experiment, but I recognize that we are now going to probably edit this. So I just want to note that that was our addition before we open this discussion.
Well, I love all of you, and I'm sure we can spend the rest of the day discussing this issue, but I think the time has come because we do have quite a few things on the agenda today. So what we can do is obviously we have a motion and resolution here. If someone wants to call for a motion and second it, and then, if anyone wants to propose amendment to the motion, by all means, we can certainly do that procedurally, and then we'll vote on it. Do we need to read the resolution into the record, or are we okay? Question?
I have a question.
Blow it up or read it.
Yep, that's fine.
Blow it
Cody.
up or read it. Yeah, okay.
Yeah. For some of us old guys, please read it for us. I have to squint my eyes to look at it.
Resolve that the Committee of Bar Examiners authorize applicants to take the California bar examination outside of California using the Measure Learning platform either remotely or in person at a designated test center, and further resolve that the Committee of Bar Examiners authorize applicants to take Phase 1 and Phase 2 of the California Bar Exam experiment outside of California using the Measure Learning platform either remotely or in person at a designated test center.
How do handwritten tests figure into this? Would Measure Learning give them at their test centers?
That's right. They would have to be in person.
Okay, so to say using their platform maybe doesn't address that question, but this would allow or could allow somebody to handwrite their exam at a Measure Learning facility outside of California.
Yes, the way it's written now, but
And we don't know if someone is taking it outside the hours that the Measure Learning designated vendor facility is open. I know the one I visited is not open after 5.
Well, that's a problem. And
for
may
the-
make it impractical for somebody to use one of their facilities. Let's go to India, which is roughly halfway around the world. It's going to be the middle of the night over there. So maybe we need to have Measure Learning commit to open up for these people. Because we probably should add an aspect that says they will take it at the same time as people are taking it in California.
Yeah. All right, folks. Questions and comments at this point?
Just won't put it, won't be able to support that, but
I think that's possible.
I mean, you could amend it to say like, provided that the test is administered during the same
Synchronously.
window, the same window at Pacific time or something like that. And then that would give us the authorization to explore with Measure whether they can offer that at their test centers.
yeah, but allow it remotely, which we know they can.
Right. But
Just
still, we would
very-
want the remote administration to be administered during the same testing window, I think. Yeah, is the point.
And Judge Reyna, I think you mentioned about the November 8th, 9th experiment. So to the extent you want to propose an amendment to add those dates, you can also do that.
Is it, I guess wonder, is that in the further resolve part? Does that encompass that?
Yes, but Phase 1 is November 8th and 9th, so we might need to, we could break that out into 2 if you wanted to, because the Phase 2 is what we were talking about earlier, that's concurrent with the July 2025 exam.
Yeah, I mean, I guess for now, I kind of liked what Alex was talking about, but I get logistically that's difficult to see how it goes. I think it would address somewhat Robbie's concerns and some other concerns if we see what happens after November 8th and 9th, and I don't even, December 6th, it might be too late to bring up another amendment, at least as to phase 2. It might mean a no-go for February if not everybody's on board, and it might mean late fees if we change, but I suppose $50 late fee or whatever it would be is better than $1,000 flight. That could be something that we do. So, I mean, I guess I would propose to amend it to just say resolved that the Committee of Bar Examiners authorize applicants to take phase 1 on November 8th and 9th remotely.
Okay.
Or in person at a designated test center. And if it's out of state, that it'll be done on the same Pacific Standard Time zone. And for us to revisit the future of this on the next meeting, December 6th, or sooner, I guess, but I don't know that we're going to be able to convene that soon.
So Judge Reyna, your proposal is going in the further resolve section. I think the resolved section needs to be removed then.
Right, that's what I'm suggesting, right, that it's just resolved that, yeah.
I think we should remove it because then we're not clear on what the rule is. We need to state the rule regarding the bar exam. Just to firmly go on record, whatever it is we think we should be doing or not.
Sorry, Paul, are you suggesting we take out the resolved? And I think Judge Rayner seems to insinuate we'll convert further resolved into resolved, and then we take out the resolved, right? That's everyone's understanding?
We need to leave the original resolved paragraph there.
I see.
Maybe you might want to change it to, you know, for instance, if you want to require that it be done inside California. I'm willing to go all in. So I like this actually. I mean, this is okay.
So it sounds like we need 2 resolutions because the first one doesn't necessarily jive with the second. Because I think the second is only limited to the experiment, whereas the first one is all encompassing. So the scope is very much different.
It's the bar exam as opposed to the experiment.
Right. Right. The scope is very different.
You want 2 resolutions and 2 votes? Is that what you're saying?
Yeah, I believe so, because they just don't necessarily jive.
Okay, so I think then we're making them both resolved. It's like motion 1, motion 2.
Right.
Okay. Sorry, Cody. This is the
No problem. This is the
my
toughest
least
part of the
favorite
job.
thing. Yeah.
And obviously, if motion 1 is passed, by definition, I would assume motion 2 will be included, or at least contemplated under motion 1. Right?
I
Is
don't
there
think
any
that's
disagreement?
right, Chair Chan. I think we need both. We need a resolution as it relates to the experiment and a resolution as it relates to the bar exam.
Then perhaps Paul Kramer. So what do you think about just in terms of motion 1, instead of saying the California bar, we say in addition to the California bar, you also include phase 1. Then if we pass motion 1, then motion 2 becomes entirely unnecessary.
Yeah, you know, I was thinking we could combine them.
So motion 1 will combine the language in 2 into 1.
Well, I just say the California bar exam and phase 1 of the California bar experiment.
There we go.
I don't know if you have to have the dates. I don't know if that matters. I think we have a common understanding of what phase 1 is.
Is that okay, Judge Reyna? I think to take out the dates.
Yeah, that's fine. I didn't know if that's what it encapsulates, then yeah, that's fine.
Okay.
One last question, because I feel like I heard it in there. Did we need to include a reference to the fact that these resolutions also require like synchronous testing in some fashion? Is that, I think Judge Reyna, you maybe mentioned that
in time zone
in your statements.
Right, in the Pacific.
Yeah.
Pacific time zone.
Well, you can say conducted, timed,
I think probably administered.
The specific time zone is a definition of a region, and that would narrow this, the allowed areas.
How about synchronous instead of administered? Or administered synchronous? Synchronous with the time zone.
Perhaps it's with those testing in California. We don't have to refer to the time zone.
Yeah, there you go.
So this is Justice Maciel. I just want to make sure I understand with the language that we just added about so long as testing is administered synchronously with those testing in California. Does that though dilute the issue that Robbie is mentioning or not? In other words, it doesn't solve the problem that Robbie is mentioning, which is testing could take place during various times if it is somewhere outside of California, because I'm concerned that people won't be testing synchronously if they're outside of California. And that's what I was hoping this could address.
Well, I understand this to say you start, if you're in New York or Mumbai, you start at the same global time as the California folks.
Yep. Can we just add the word so long as all testing is administered?
We do not say no to you, Justice Maswala. All input is well taken.
And actually the authorizing the first line should be plural, I think.
Yeah, this is Robbie. I'm really sorry that a representative from Measure Learning isn't here for this, because I don't think they can do it. And I just want to say, remind CBE members, these are not owned and operated Measure Learning test centers. The one I visited was a private for-profit school where Measure Learning rents 2 rooms in it. It's not a Measure Learning center. So I'm not sure that they can say something that's going to be administered at 9 p.m. Mumbai time, that they have a facility that will be open. I know this school closes at 5. So and again,
that may limit access to people in Mumbai, but they'll still have the ability to remotely test.
That's right. Yes.
But if we're offering in person as a designated test center, I just thought about this.
Then perhaps
And
we
this-
need to separate out the motion so that one is for remote, one is in person. Have you thought about that?
I think we're splitting it too much, and
Exactly. It gets a little more.
and Cody, Audrey, Amy, I'm very loyal to the board. Please don't take offense. I know time was put into getting this motion on, but it's incomplete. I'm not sure if everybody thought about what about a test center in India or Shenzhen, where out of state, out of country applicants are. And that's the purpose of the CBE. This is what we do. We flesh it out together, and we don't all agree, but so please don't take offense that I think this is premature, and I don't want anybody in the state bar to be defensive just because it's on the calendar. Please don't be. This is our role to work together to make sure we're being fair to all our applicants and preserving the integrity of the bar exam. It's hard to do all this on the fly today, which is why I say,
Well,
so please don't.
we're not taking, I'm not anyway, taking any offense. I think, so motion 1, if you vote on this motion and pass it, it would mean someone outside of California or globally would have to take it remotely or come to California to a test center. That's what that motion would mean, which I don't know is a bad outcome in terms of what we've been talking about. So
Also, one thing, I think we lost out on one thing. Obviously, this experiment is contingent on the Supreme Court approving it. The court hasn't said anything yet, hasn't ruled on this yet. And so I don't know if we need some kind of language to say contingent on the experiment being approved by the court.
So the
Other-
incentive is what's in front of the court, Alex. So the incentive, right? So the experiment, we're going to field test the questions. Whether or not a lot of applicants will choose to withdraw if the incentive is not approved, I don't know. But I think we do want to include, you know, this.
Okay.
But Alex, you are correct as it relates to the bar exam and the remote administration because that petition is pending.
Got it. Thank you, Jean.
Can I
Hey,
just?
Cody, oh, sorry. I was just gonna, Cody, can you add the last sentence to the motion too as well? So long as, yeah.
To motion 2.
Right.
Yep. Replicate the same language.
I just wanted to respond to Robbie too. We're definitely not taking offense. And also, I don't think this is, I do think this is an important thing that we need to decide today and not to rush it. But the way I read the motion is, and this will allow us to work with measure in the contracting process, we would only permit the exam to be taken outside of California in a designated test center if measure is in fact able to offer it in one of its test centers during the same time window, right? So if they're not, then that won't be an option. And that's what what this motion 1 would be limiting it to, right? So I think we're able to take this vote, and I think we're able to make that determination with measure after you have voted. And what I'm understanding the committee to be saying is, we're not okay with having somebody take this outside of California if that means that they have to stick to the test centers 9 to 5 in New York, and that's not going to work, right? So the only way the way that I read this motion is that if measure is able to deliver a test center outside of California that can be open during the hours that we need them to be open, then we can do it. And if they can't, then we won't. So I do think that this gives us sufficient direction to be able to do that negotiation with measure. And the fact that they do contract out with other, that these are vendors per se, that they subcontract with, I don't think that means they don't have control over them, and we're, again, through the contracting process, they would be responsible to make sure that all the people that they're subcontracting with, all these test centers, would still meet the criteria that we are putting in the contract.
All right, folks, I think the time has come. We are running out of time. We still have quite a few things on the agenda. So unless there are additional questions, I need someone to call for a motion.
I'll make motion 1.
Thank you, Mr. Kramer. Second?
I'll second. This is Vince.
Okay, Vince. Any additional discussion or debates among the members? Hearing none. Devin, is yours.
Dr. Bolton,
No.
Robert Brody,
No.
Dr. Cow, Dr. Cow.
He stepped out for a meeting.
Okay.
Meeting, yeah.
Kareem Gangora, Larry Kaplan,
Yes.
Paul Kramer,
Yes.
Alex Lawrence,
Yes.
Esther Lynn, Justice Misiwala,
Yes.
Bethany Peak,
No.
Ashley Silva Guzman, Judge Reyna,
Yes.
Vince Reyes,
Yes.
Alan Yokelson,
Yes.
Alex Chan.
Yes.
With 8 yeses and 3 nos, the motion passes.
Did good.
Okay. So do we need to vote on the second motion then, since the first one is a go?
I don't think so.
No, it was subsumed in the first. The first dealt with
Exactly.
both the exam and the experiment.
Okay. Thank you all. That was a very fruitful discussion. I know we're
Here.
sort of very close to the lunchtime. I don't know if we want to go through the next agenda item. Unless anyone has issue, I personally would like to go through agenda item 4.3 before taking a lunch break. Any objection? Okay. All right, well then let's go through agenda item 4.3, which is the action on revisions to the multi-jurisdictional practice and foreign legal consultant rules, recommendation to circulate revised rules for public comments. Tara, Christina, and David, you have the floors.
Thank you. Try to make this brief. And just to confirm, you can see the PowerPoint, okay?
Yes, thank you, Tara.
Thank you. And we just want to say thank you as well to Paul Kramer and Bethany Peak, who have worked with us on these second round of revisions to the rules. Okay, and so just as a quick reminder to the committee, these rules were before you last year in June. At that point, the committee did approve recommending to the board that these revised rules go out for public comment. But as you may recall, we paused our effort to revise the rules, and so we've since picked them up this year, and we've made further revisions from some of the things we've learned along the way. Okay, and the key themes of the rule revisions, eliminating outdated barriers to participation, adding pertinent information, and ensuring consistency across the rules, both the rules of court and the state bar rules. And then, as you've seen, the moral character rules transitioning to gender neutral pronouns. Okay. And so as a quick reminder, there are 3 programs in the multi-jurisdictional practice program. We have registered military spouse attorneys, registered legal aid attorneys, and registered house counsel. And we also have our foreign legal consultants. So these are just some of the proposed changes that you can see that have existed. Again, and some of the most important ones for registered military spouse and registered legal aid is creating those tiered levels of supervision. So for those attorneys who have less than 5 years of experience or less than 3 of the last 5 years in actual law practice, they would have a higher level of supervision than those with more experience. For registered military spouse, we have this conditional approval, so that way if they do meet the requirements of the program, but have not yet secured a supervising attorney, they do have our conditional approval to hopefully go and get that supervising attorney, make it a little bit easier for them. And one change across all of the MJP programs is replacing the current MCLE requirement that they complete the 3-year requirement within the first year, is that just switching them to the new attorney training program, and then they would complete the MCLEs on the normal attorney schedule. And then finally, I think for registered military spouse and registered legal aid, eliminating some of the barriers. So right now, for both of those programs, an applicant cannot have taken and failed the bar exam within 5 years before initially applying. And once approved for the program, they have a 5-year practice limit. So both of those are being removed. Okay. And so the current proposal, just the further revisions, these ones are relatively minor, but so we wanted to create some sort of consistency across the rules of court. So you'll see that some of the sections were moved as well as renamed. And then at the request of the Chief Trial Counsel, who we asked for feedback, we had suggested in a failure to comply and disciplinary authority subsections, just to make it explicitly clear that these folks are subject to the disciplinary authority of the California Supreme Court and the State Bar. Here you have an example from the registered military spouse. The wording tracks across the other programs. And I'm going a little bit quickly, so feel free to interrupt me if you have any questions. And then, so generally for the rules of the State Bar, we added in, as you've seen from some of our other rules like moral character, just creating consistency about when an application will be considered complete, incomplete or abandoned, just kind of general clarifying grammatical changes, and then revising the suspension and termination rules. So as far as we can recall, the situation does not come up where an MJP or FLC attorney has been subject to suspension or termination under some of the disciplinary proceedings. However, the current rules are vague, and so we want to make sure that the process is clear if this does occur in the future. And so the way that the revised rules are intended to read is that suspension, there can be administrative reasons, for example, failing to do the annual renewal, pay their annual renewal fee, completing either the new attorney training in the beginning or their MCLE requirements. And then they can be reinstated as long as they rectify those administrative reasons for suspensions within 6 months. However, if they do fail to complete those, then they would be terminated from the program. They can still reapply. You can see I won't go down the whole list, but we just wanted to call it specifically as well for the suspension. So there's 3 times when they would be suspended for more disciplinary reasons. So one is when the state bar initiates disciplinary proceedings in the state bar court by filing notice of disciplinary charges, or the state bar, so be it OCTC and the MJP or FLC attorney, enter into a stipulation of facts and conclusions of law, or stipulation of facts, conclusions of law, and discipline. And so it's only those MJP or FLC attorneys who have been terminated from the program for one of these disciplinary reasons, meaning discipline was actually imposed, that they cannot reapply. Others can always reapply for the program. I think that's actually my last slide. So let's throw it to my colleagues who worked on this with me, Christina and David, to see if they have anything to add. And then if
have anything big to add, just one quick big picture comment. Tara mentioned briefly making the 3 programs in the MJBP rules have sort of consistent rules. We did some reorganization among the rules of court, for example. This is part of our effort to make everything more clear. We got rid of excess verbiage, unnecessary legalese. I think these rules should be user-friendly. People should be able to read them and understand them. And so, that's what we're thinking about when we work on any of these rules. So I just wanted to make that quick comment. Hopefully we succeeded.
Thank you. And then I guess Paul or Bethany, as the members that worked with us, did you have anything to add?
One feature to just highlight is that for 3 of the 4, you can apply for the program and be approved while your moral character determination is under review, as long as you've applied for it. The thought there being that you came to us from another bar, which presumably, by admitting you, has determined that you are of good moral character, and so we don't need to wait for us to finish the process of revisiting your degree of moral character. If our review ultimately came back negative, then you'd be kicked out. But that's just a feature that if you saw it, you might find a little unusual. But I think there are reasonable protections in there, so I don't have a problem with it.
Thank you, Paul. Bethany?
I didn't have anything substantive to add. Just wanted to thank Tara and David and Christian, because I know I've been involved for since early 2023 with these revisions. So I know you guys have been doing it way longer. So thanks so much for all the hard work. And I don't have anything else to add.
Thank you. And are there any questions? Not seeing or hearing any. I'll put up the motion if anybody's so inclined to make it.
This is Bethany. I'll make the motion.
I'll second.
Any additional discussion or debates? Hearing none. Devin, please take the roll.
Dr. Bolton,
Yes.
Robert Brody,
Yes.
Dr. Cow, Kareem Gangora, Larry Kaplan,
Yes.
Paul Kramer,
Yes.
Alex Lawrence,
Yes.
Esther Lynn, Justice Misiwala,
Yes.
Bethany Peak,
Yes.
Ashley Silva Guzman, Judge Reyna,
Yes.
Vince Reyes,
Yes.
Alan Yokelson,
Yes.
Alex Chan.
Yes.
With 11 yeses and 0 nos, the motion passes.
Thank you, Devin. Audrey, I know we are past noon. Would you like to take a lunch break, everyone, or should we keep going? I wanted to defer to the committee.
I think people probably want a break.
Okay, well, let's take a lunch break. I'm hoping that we can take a 30 lunch break, so we can continue on just because we have quite a few things at the agenda. But if anyone wants more than 30 minutes, please let us know. Okay. Well then, Audrey, I think we can go into the lunch break.
All right, see you at 12:35.
Thank you all.
Hey, what should we do?
I'm just
Looks like we're back. And everyone is still muted.
The only thing I saw was the committee signs.
I hope everyone had a good lunch. I don't know if everyone else is back, but it looks like at least this the LA office and the San Francisco office are both ready. And Dr. Kyle, we missed you. Glad you're back. Okay. Looks like Amy is having a
The
very
host would
good
like to
lunch.
unmute you. Okay.
Great salad. I don't mean
Now
to
we
pick-
can hear them.
It does look good.
Los Angeles, you're unmuted. Could you please mute while we're while Chair Chan gets started?
Oh, I muted the room.
Don't mess with Devin. Your mic will be removed.
Can you hear us now?
Yeah.
Exclamation. Natalie, I'm sorry, I ran the smart and final to get food for us. I missed you.
No problem. Just, you know that we're here for you.
Guys,
But are we starting now?
I believe
Brody?
we're gonna start. What's the next?
Oh,
4.4?
really? How was that? Yeah.
All right, folks. Welcome back. I'm going to if Devin can mute everyone, I'm going to go to the next agenda item now that we're back. So the meeting is now resumed. Right before the lunch, we were on agenda item 4.3, and we have 4.4. But my understanding, Audrey, is that we're skipping this item. Am I correct?
Ah, sorry, you were correct. Yes, that is correct. We're gonna hold that till after close.
Okay. Then let's move on to agenda item 4.5, which is the discussion on findings from first year law students exam and the California bar exam surveys. I do believe Cody and Amy have a report for us, so take it away.
Yeah, thank you so much, Chair. We have a few items today that I think are kind of data and chart heavy, but I hope it's appreciated because we really, I think, in the last few months, dug into topics in new ways that I think will be really valuable to the committee. So yes, today is a discussion on the post-exam surveys that are, excuse me, that are distributed to students after they sit for state bar exams. We'll break it up into both the first year law students exam and the California bar exam surveys. But I want to just first highlight a few, maybe a few points of background before we get into this. First, I think the value of this presentation is twofold. One, I think the committee will really benefit from reflecting and assessing on the impact of recent committee actions. And then I think also there's information here that'll continue to inform our future actions. And I also want to note, you're going to see in this presentation some new information. And the reason that we've been able to bring new information forward is that we've been collaborating with our colleagues in the Mission Advancement and Accountability Division, who really helped us refine some of these initiatives and ask kind of exciting questions in new ways. And so I hope that some of what we see here today is fresh and really benefited from that collaboration. So starting with the first year exam, and actually let me share my screen here. Okay. So starting with our first year exam survey, I wanted to first flag, this is a survey from June 2024. So that marks only the second first year exam where the primary administration modality was in person at vendor-owned test centers. And that has been a topic of discussion today. So I think some of the findings will be relevant. It is also the first survey to measure sentiment from test takers after the committee approved of the first year exam changing to a multiple choice only exam. So that will be some useful context as we talk about these numbers. And then just to highlight, because our first year exam is different than our bar exam, I want to put some numbers on kind of who these individuals are that took this survey. So we had about 158 responses, which is a majority of the individuals who sat for that exam. 42% of the respondents are first generation college students, and 73% are first generation law students. 29% reported that English was not their first language, and 2/3 work full-time while 1/3 are caregivers. So I want to just put that out there. Our first year law students exam population is definitely unique from the broader law student population in that they're often representing disadvantaged groups or often face unique personal situations that other test takers do not. Okay, so let's get into our findings. So we found that satisfaction in the June 2024 exam increased by about 24% compared to, or 24 percentage points compared to the June 2023 exam. I think this is one of the most important measurements. We talked a lot today about making sure that applicants have a test taking experience that meets their needs and expectations. But we also kind of dug into what the test center experience looks like. So we found that overall satisfaction with testing in one of these vendor-owned test centers was 83%. And only 6% of the test takers found that their experience in a test center was dissatisfying. We list below the overall experience a few categories that some of them even raised today, but staff professionalism, the computer equipment, and even the testing environment all rated as satisfactory to a large majority of the test takers for this exam. Now, even though the exam was primarily delivered remotely, or excuse me, in test centers, there were test takers who were able to take the exam remotely due to an extenuating circumstance. And so this really posed for us an opportunity to get a sense of these two modalities before really even the discussion was raised or the discussion was finalized for the February exam. So we used the survey as an opportunity to measure some of the unique benefits of the remote exam experience as well. And what we found was that having a live proctor in a remote exam made 44% of the respondents feel less concerned about their technology issues. And if we move to the next slide, we found that 46% who tested in that remote setting with a live proctor felt more comfortable asking questions of the proctors during the exam day. So we're really hopeful that this is an early indication that future use of live remote proctoring will provide a more comfortable testing experience because test takers will have somebody there who can perhaps assist them through the process, assist them with small technology issues and things like that. Now, I want to turn to the multiple choice question only design change, because I think that was a really big step that the committee took. And there were concerns from stakeholders about how this might impact applicants, and our surveys really help us understand what that impact looked like. So first and foremost, there were concerns that that applicants wouldn't know that this change was in effect. We actually found that very few individuals were unaware of that test change. This chart here shows us the initial source of the information for those test takers who said they were aware of the change. And so we found well over 90% of test takers were aware of the test change. And I think I want to just put a spotlight that, the state bar, along with our law school partners, really did a great job of communicating that change to test takers, and this chart really bears that out. Beyond the awareness aspect, there were certainly understandable concerns that a change to an exam might impact preparedness. But what we actually found in the survey is that 74% of test takers felt more prepared due to the exam changing to a multiple choice only exam. And we also found in this next slide that 62% of test takers felt that their performance on the exam was better because of the fact that the exam was a multiple choice only exam. So I think, collectively, that goes to show that the committee's action to design or to move the first year exam to a multiple choice only exam had a positive impact. And we'll summarize our findings in just a moment, but let's move over to our July 2024 bar exam survey. So this survey posed a unique opportunity because this was the last survey of applicants representing our traditional exam administration model. We see here that we had far more responses, understandably, because the population of test takers is larger. But some of those trends related to the population of test takers, kind of show themselves here as well. We have a large portion of first generational college students and a vast majority of first generation law students. And interestingly, in the bar exam population, there's also a significant number who report that English is not their first language. So all of this just goes to show us some of the diversity of experience that our test takers have. But I want to get into more about the administration because I think that's most important to the committee here. So we saw in the July 2024 administration an increase in satisfaction as we did with the June exam. That was driven mostly by an increase in the category of very satisfied and a decrease in the category of dissatisfied. But looking at satisfaction as a whole and dissatisfaction as a whole, we see that that satisfaction actually increased from between July 2023 and July 2024. Some of these issues, we ask applicants to label some of the distractions and issues that they face. And I wanted to flag a few of these because it actually came up earlier today in the discussion. The commonly reported distractions that we found were temperature issues, noise distractions, lighting problems, and proctor interference. I think it's interesting to note these because I believe, and I think staff are optimistic, that through a remote exam administration, many of these issues will be non-existent. And I think even in a test center model, we will find that there are far fewer concerns with these issues. You can imagine, how a noise distraction at a large test facility can impact many applicants, but in a smaller test center, it can be more of a contained and less impactful issue. So we will continue to survey our applicants to get a sense of what kind of issues and distractions happen during the exam, but we might find next year that some of the issues listed here are no longer of the same concern. Now, we talked about this earlier, but I think these were some of the most important findings. So again, we worked in partnership with the Admission Advancement and Accountability Division to introduce some new questions to understand the financial and logistical burdens. It's somewhat serendipitous because in the court's order related to the future bar exam, they've asked or directed staff to research things like the financial burden of the exam. And so we're a little ahead of the game here. But what we found in our July 2024 survey, again, is that over half of applicants spent more than $500 on lodging and travel for the exam, and nearly a third spent over $1,000. And we covered this earlier, but we also found that a large number of applicants who responded to the survey traveled a great distance to get to their test center. So we found that almost 1/4, 24%, traveled over 250 miles to get to their test center. Now, I alluded to this earlier, but we also have a few questions in our survey related to technology issues. And I wanted to raise here that, the existing exam, as it is, even though it's in large test centers, still relies on, computer exam delivery. Although it's not a live proctored situation, technology plays a big role. And what we found is that 85% of applicants report having no technology issues at all. We found that 5% have software issues. And then, a increasingly smaller number have computer hardware and other technical issues. But I think this last piece, no access to a laptop computer, 2%. I think that's really important because we were talking, as Larry mentioned earlier, about access to the exam. And we believe that a remote model improves access in some ways, but we've certainly heard from some stakeholders that are concerned about relying more on technology and what that means for some individuals. I would point to this number to suggest that the number of individuals that have issues accessing the necessary computer equipment is actually quite small. And knowing that we have the test center model as a safety net, I feel that this population is will be able to be well supported if they do not have a access to a computer, because it's a manageable number and it's quite small. And then looking towards the